Case Law Summary. Principal, of CUS, General, Mumbai versus Unison Clearing P Ltd 2018 361 221 Bomb dot. High Court of Judicature at Bombay. Core issue: whether the time limit prescribed for issuing a show cause notice (SCN) for revocation suspension of a customs broker license under regulations 19-20 of Customs House Licensing Regulations CHLR 2013 is mandatory, strict, failure invalidates proceedings, or directory, guiding, delay does not automatically invalidate proceedings. Held, decision of the court. The time limits are directory, not mandatory. Key findings but are legal principles. Time limits are directory in nature. The court held that strict and inflexible adherence to timelines is not feasible in all cases. Treating timelines as mandatory would defeat the purpose of the regulations and legislative intent. No fatal consequence prescribed. Since no specific consequence is provided in the regulations for non-adherence to timelines, delay does not invalidate the inquiry or final order. Delay must be explained. If prescribed timelines are exceeded, the authority must justify the delay with reasons. Unexplained or unreasonable delay may be questioned, but delay per se is not fatal. 90-day period not absolute. Delay in immediate suspension or initiation of inquiry within 90 days does not vitiate the Commissioner's action. Sestad's view rejected. The court held that Customs, Excise and Service Tax Appellate Tribunal, Sestat, was not justified in setting aside the suspension solely on the ground of delay between suspension and SCN. Interpretation of the word shall. The word shall does not automatically mean mandatory. Whether a provision is mandatory or directory depends on intent of the legislature, purpose of the law, consequences of strict interpretation, practical impact, why this case is important. Customs brokers cannot escape proceedings only due to procedural delay, unless the delay is arbitrary and unexplained. Departmental actions remain valid, even if timelines are crossed, provided reasons are recorded. This judgment provides administrative flexibility while still ensuring fairness. One-line ratio decidendi. Case law summary. Commissioner of Customs versus KM Ganatra को 2016 15 SC. Supreme Court of India. Core issue. Whether Sestat was justified in restoring a Customs House agent (CHA) license after serious and repeated violations, including subletting of license, which caused immense loss to government revenue. Facts in brief. The CHA, KM Ganatra को, committed repeated violations of CHA regulations. The most serious charge was subletting of license, which is a grave professional misconduct. The license was suspended and later revoked by the Commissioner. Customs, Excise and Service Tax Appellate Tribunal, Sestat, restored the license after 3 years, taking a lenient view. Held, decision of the court. Supreme Court set aside Sestat's lenient approach. Restoration of license was held to be improper. Revenue's appeal succeeded on merits. Key legal findings. 1. Serious misconduct must be viewed strictly. Subletting of CHA license is a serious violation, not a technical lapse. Such misconduct shows a chain of illegal acts, leading to loss of revenue. Leniency is not warranted in such cases. Though Sestat exceeded discretion. Although Sestat has powers under Section 129B of the Customs Act 1962. Exercise of discretion must align with facts and gravity of misconduct. Restoring license merely because 3 years had elapsed from suspension was legally unsustainable. 3. Power of Sestat, but not arbitrary. Supreme Court clarified. Sestat does have power to modify or restrict the period of revocation. However, such power must be exercised judiciously, not mechanically or compassionately. 4. Appeal dismissal, question of law kept open. Supreme Court dismissed the appeal on merits. Question of law was kept open, meaning future appeals raising similar legal questions cannot be rejected merely because facts look similar. Regulations legal provisions involved. Regulation 1323 Customs House Agents Licensing Regulations 1984. Regulation 22 Customs House Agents Licensing Regulations 2004. Section 129B Customs Act 1962. Practical significance of the judgment. Establishes zero tolerance for license subletting. Protects revenue interest over misplaced sympathy. Limits CESTAT's discretion in serious professional misconduct cases. Landmark ruling for customs brokers charged disciplinary proceedings. One-line ratio decidendi. Subletting of a customs house agent license is a grave misconduct causing revenue loss. Such violations do not justify leniency, and CESTAT cannot restore license merely on passage of time. Case Law Summary. KTR Logistic Solutions Pvt. Ltd. versus Commissioner of Suez. Chennai 2020 371 ELT 685 MAD. High Court of Judicature at Madras. Core issue. Whether the time limit prescribed for completion of proceedings for suspension revocation of customs broker license under the Customs Broker Licensing Regulations is mandatory or directory. Held, decision of the court. Time limit is mandatory, not directory. Key legal findings. 1. Overall 9-month time limit is compulsory. The regulations prescribe an overall time limit of 9 months from the date of receipt of offence report covering issue of show cause notice, submission of enquiry report by DCAC, passing of final order by Commissioner. This timeline is intended to protect the substantial right of the customs broker to carry on business. 2. Delay affects fundamental business rights. Non-compliance of the time limit directly affects the right to livelihood and business continuity of the license holder. Hence, such timelines cannot be treated as procedural or flexible. 3. Mandatory versus directory, clear distinction. Unlike some other High Court views, Madras High Court held time limits are substantive safeguards, not mere administrative guidelines. Therefore, strict compliance is required. Important directions, strictures against revenue. The court issued clear operational guidelines to prevent misuse and delay. Time-bound completion. If license is suspended, immediate or pending inquiry, final proceedings must be completed within the prescribed time frame. B. Deemed restoration. If no final order is passed within the stipulated time, suspension shall be treated as lapsed and license shall be deemed to have been restored. C. Accountability of officers. If timelines are exceeded, officials at each stage must submit explanations to higher authorities. Reasons for delay must be properly recorded. D. Disciplinary action against erring officials. Based on explanations, corrective or disciplinary action should be taken against officials responsible for delay, after giving them an opportunity of hearing. E. Exception bona fide reasons. Before initiating action against officers, it must be examined whether delay was due to bona fide reasons beyond control or due to fault deliberate non-cooperation of the licensee. Legal importance of the judgment. Strongly protects customs brokers from prolonged suspension. Introduces doctrine of deemed restoration. Fixes institutional accountability on revenue authorities. takes a strict view contrary to the directory approach of some earlier rulings. Position in case law hierarchy. This judgment differs from Bombay High Court view, Unison Clearing PVT, Ltd. Timelines held directory. Creates a clear High Court divergence on mandatory versus directory interpretation of time limits. Very important for Madras jurisdiction and persuasive elsewhere. Case law summary. Comma of CUS. General. Mumbai. Versus Srinivas Clearing Shipping. I. PVT. Ltd. 2022 380 ELT 60. Bomb dot. High Court of Judicature at Bombay. Core issue. Whether the time limits prescribed under Regulations 1920 of the Customs House Licensing Regulations 2013 for revocation suspension of customs broker license are mandatory or directory, and whether Sestat was justified in restoring the license solely on the ground of delay. Held, decision of the court. Time limits are directory, not mandatory. Sestat's order restoring license was set aside. Matter remanded to Sestat for fresh adjudication. Key legal findings. 1. Timelines under CHLR 2013 are directory. Bombay High Court reaffirmed its consistent view that timelines in Regulations 9-20 are not mandatory. Delay alone cannot nullify proceedings. 2. Tribunal failed to consider revenue's explanation. Sestat only examined delay in commencement of proceedings. It ignored explanations given by revenue for delay in completion of proceedings. Such selective consideration amounted to non-application of mind. 3. Serious allegations ignored by tribunal. The tribunal failed to discuss crucial facts, including smuggling of red sanders. Statements recorded under Section 108 of Customs Act 1962. Modus operandi of alleged smuggling network. Investigation under Conservation of Foreign Exchange and Prevention of Smuggling Activities Act 1974 COFEPOSA. Misuse of DPB scheme. Destruction of post-shipment documents. Forgery and fabrication of export documents. Admission by main accused of involvement in smuggling. 4. Shareholding pattern overlooked. Court noted that main accused controlled 99.9% shareholding of the respondent company. This fact was relevant to establish nexus but was not examined by Sestat. 5. Restoration of license was unjustified. Restoration of license was held to be completely misplaced. Result of complete non-application of mind. Serious economic offences cannot be brushed aside on technical delay alone. Legal consequence. License restoration set aside. Matter remanded to Sestat for fresh decision. Tribunal directed to consider gravity of allegations. Revenue's explanation for delay. Full factual matrix and evidence. Case law summary. Shabir Ahmed Saeed versus PR, of CUS, Preventive, Tiruchirappalli, 2020 373 ELT4C, Mad. High Court of Judicature at Madras. Core issue. Whether the conduct of an oral examination for upgradation from H card to G card under the Customs Brokers Licensing Regulations 2018 CBLR 2018 was legal and valid when the regulations prescribed only a written examination. Held, decision of the court. Oral examination held to be illegal and arbitrary. Public Notice Number 1 of 2019 struck down. Petitioner directed to be appointed as G card holder if otherwise eligible. Key legal findings. 1. Oral examination not authorized by regulations. Regulations 2, H and 13 of CBLR 2018 do not provide for an oral examination. Conducting an oral test without statutory backing is ultra vires the regulations. 2. High possibility of bias in oral tests. The court observed that element of bias can always exist in oral examinations. To minimize bias, judicial precedents consistently hold that oral examination marks should not exceed 25% of total marks. In this case, written exam 100 marks, oral exam 100 marks. This was held arbitrary and unreasonable. 3. Lack of transparency. The nature of oral examination, criteria, and basis of assessment were not disclosed. Out of 21 candidates who passed the written exam, only to clear the oral exam, raising serious doubts about fairness. 4. Public Notice invalid. Public Notice Number 1 of 2019, which introduced oral examination, was held contrary to the regulations, illegal and unconstitutional. Hence, it was quashed. 5. Purpose of examination clarified. The court made a significant observation. The object of any examination is to ensure that a qualified candidate is promoted, not to reject candidates. If an examination is designed to eliminate candidates, it must be struck down. Legal consequence. Oral examination set aside. Public notice introducing oral exam quashed. Petitioner entitled to G card upgradation based on written exam result. Reinforces fairness, transparency, and statutory compliance in departmental exams. Statutory provisions involved. Regulation 2H. Definition related to customs broker employee cards. Regulation 13. Examination and qualification norms. Customs Brokers Licensing Regulations 2018. One-line ratio decidendi. An oral examination for G card upgradation not prescribed by CBLR 2018 and carrying equal weight as written test is arbitrary, biased, and illegal. Examination process must promote merit, not rejection. Case law summary. Asian Freight versus Principal, of COS Airport Administration 2020 373 123 Call. High Court at Calcutta. Core issues. Validity of immediate suspension of customs broker license under Regulation 19 of CBLR 2013. Maintainability of writ petition at show cause notice SCN stage. Whether time limits under Regulation Bs of CBLR 2013 are mandatory or directory. Relevant date for computing 90-day period for issuance of SCN. Facts in brief. Attempted smuggling of high-value misdeclared goods, 5.5 crore rupees, from Singapore to India in the guise of Nepal import. Goods appeared liable to confiscation under Sections 111, L, 111, M, 111, N of the Customs Act 1962. Petitioner, customs broker, mechanically filed CTD without due diligence, violating obligations under CBLR 2013. Offense report received on April 19th and 22nd, 2016 license suspended within 2 weeks under Regulation 19(1). Held, decision of the court. Suspension of license upheld. Time limits under Regulation 20 held directory, not mandatory. Writ petition dismissed, no interference warranted. Key legal findings. 1. Immediate suspension under Regulation 19 justified. Court held this was not a case of absence of reasons for immediate action. Continuation of broker's business was found prejudicial to revenue interest. Serious allegations of smuggling justified urgent preventive suspension. 2. Omission to discuss precedents not fatal. Even if authority did not expressly distinguish earlier judgments, mere omission is not fatal when reasons for suspension are otherwise sound. 3. Writ against SCN, limited interference. Reiterated settled law. Writ petitions at SCN stage should be rare. Only entertained when notice is wholly without jurisdiction. Petitioner was directed to reply to SCN and face adjudication. 4. Time limit under Regulation 20 directory. Regulation Bs does not prescribe any consequence for failure to issue SCN within 90 days. Applying settled Supreme Court principles. Where no statutory consequence is provided, time limit is directory. Distinguished from Section 110(2) of Customs Act 1962, which expressly provides consequences. 5. Dual purpose of 90-day time limit explained. The court clarified the rationale. I. Check on authorities. Prevents proceedings being kept pending indefinitely. Delay may expose officers to administrative disciplinary action. 2. Protection to customs broker. Ensures broker is not proceeded against on stale allegations. But to say that every delay beyond 90 days would nullify proceedings is unacceptable. 6. Relevant date for computing 90 days. 90-day period starts from the date offense report reaches the competent authority, Principal Commissioner, not earlier. SCN dated 18 July 2016 held within time, as offense report received on 22 April 2016 was proved. 7. No automatic revocation of suspension. Court refused to apply earlier division bench ruling MD. Yesin, mechanically. Held that if proceedings are not completed within time under Regulation 20(7), petitioner may approach court afresh later. At present stage, no relief granted. Statutory provisions involved. Regulation 1920, Customs Brokers Licensing Regulations, 2013. Sections 111L, 111M, 111N, Customs Act 1962. Article 226, Constitution of India. Legal position reinforced by this judgment. Immediate suspension permissible in serious smuggling cases. Time limits under CBLR 2013 generally directory. SCN stage writs discouraged. Relevant date receipt of offense report by competent authority. One-line ratio decidendi. Time limits under Regulation Bs of CBLR 2013 are directory in absence of statutory consequences. Serious allegations justify immediate suspension under Regulation 19, and writ interference at SCN stage is exceptional. Overall trend after 6 judgments, quick insight. Bombay Calcutta High Court's Time Limits Directory. Madras High Court, KTR Logistics, Time Limits Mandatory. Serious misconduct smuggling cases, courts lean in favor of revenue. If you want next, I can. Prepare a master comparative table of all 6 cases. Frame ready-made arguments, revenue versus broker. Explain which case to cite depending on jurisdiction. Convert these into exam departmental notes. Case law summary. Premier Shipping Agencies versus Commissioner of Customs 2015 315 ELT 27 Dale. High Court of Delhi. Core issue. Whether appeals under Regulation 21 of the Customs Brokers Licensing Regulations 2013 CBLR 2013 are restricted only to orders of revocation Reg. 18 and suspension Reg. 19 of Customs Broker License, or whether they extend to all orders passed by the Commissioner under the regulations. Held, decision of the Court. Regulation 21 is valid and wide in scope. Appeal lies against all orders of Commissioner under CBLR 2013. CESTAT's restrictive interpretation overruled. Key legal findings. 1. Regulation 21, broad appellate remedy. The Delhi High Court held that appeals under Regulation 21 are not confined to revocation orders, Reg. 18, or suspension orders, Reg. 19. Appeal is maintainable against any order passed by the Commissioner under the CBLR 2013, including orders under Regulation 23. Though, power of CBEC under Customs Act 1962. Under Section 146, 2 of the Customs Act 1962. Central Board of Excise and Customs CBEC has wide authority to regulate all facets of the business of customs brokers. This power is not confined or circumscribed to specific clauses only. 3. No lack of legislative competence. The court rejected the argument that CBEC lacked authority to provide an appellate mechanism under Regulation 21. Held that providing appeals against Commissioner's orders is well within statutory power. 4. CESTAT Mumbai view overruled. The contrary view taken by Customs, Excise and Service Tax Appellate Tribunal, Mumbai. In S&M Agency 2014 304 ELT 255 Tridot was expressly overruled. Legal impact of the judgment. Strengthens right of appeal for customs brokers. Clarifies wide appellate jurisdiction under CBLR 2013. Prevents arbitrary denial of appellate remedy. Settles conflict between tribunal and High Court views. Practical takeaway. Any adverse order passed by Commissioner under CBLR 2013 is appealable under Regulation 21. Customs brokers need not approach writ courts directly in most cases. One-line ratio decidendi. Regulation 21 of CBLR 2013 validly provides a right of appeal against all orders passed by the Commissioner under the regulations and is not confined to suspension or revocation orders. If you want next, I can. Prepare a consolidated appeal remedies under CBLR chart. Draft an appeal memo format under Regulation 21. Link this judgment with Asian Freight Unison clearing cases. Create exam-ready one-page notes on appellate jurisdiction. Case Law Summary. United Customs House Agency PVT Ltd versus Union of India 2016 376 Call. High Court at Calcutta. Core issues. Scope and limits of power to prohibit a customs broker from working under Regulation 23 of CBLR 2013. Requirement of show cause notice and hearing before issuing a prohibition order. Application of principles of natural justice in cases of urgent prohibition. Held, decision of the court. Prohibition power is extraordinary and must be used sparingly. Prohibition cannot be permanent or indefinite. Post-decisional hearing satisfies natural justice. Impugned prohibition order set aside due to prolonged inaction. Key legal findings. 1. Nature of power under Regulation 23. Power to prohibit a customs broker from operating is extraordinary in nature. Intended to protect revenue interests in exigent situations. Such power cannot substitute regular proceedings of suspension, Reg. 19, or revocation, Reg. 20. Though prohibition cannot be indefinite. Once prohibition is ordered, revenue must promptly initiate suspension or revocation proceedings. Long-standing prohibition without further action is illegal. In this case, prohibition order issued several years earlier. No subsequent proceedings initiated. Order set aside. 3. No prior SCN or hearing required in exigency. Court held. Predecisional show cause notice or hearing is not mandatory. In cases involving smuggling networks, collusion with importers-exporters, revenue risk, immediate prohibition may be necessary. 4. Requirement of reasons and post-decisional hearing. Though prior hearing not required, authority must immediately disclose reasons for prohibition and provide a post-decisional hearing. This satisfies principles of natural justice. 5. Clarification on precedents. Court clarified an important principle. It is the reasoning of a judgment, not the final order alone, that operates as a precedent. Orders without reasoning cannot be blindly relied upon. Legal consequence. Prohibition order quashed due to inordinate delay. Revenue given liberty to initiate fresh proceedings as per law. Clear safeguards laid down for use of Regulation 23. Statutory provisions involved. Regulation 23, Customs Brokers Licensing Regulations, 2013. Article 226, Constitution of India. One-line ratio decidendi. Prohibition under Regulation 23 of CBLR 2013 is an extraordinary, temporary measure that may be imposed without prior hearing in exigent circumstances, but must be followed by prompt action and post-decisional hearing. Indefinite prohibition is impermissible. Practical significance. Prevents misuse of prohibition power by revenue. Balances urgency versus natural justice. Useful authority for challenging long-standing prohibitions. If you want, I can now create a master table of all 8 judgments. Map which regulation 19, 20, 21, 23 applies to which situation. Prepare ready-to-use writ appeal arguments for customs brokers. Summarize mandatory versus directory jurisprudence in one page. Case law summary. D.H. Patkarko versus Commissioner of Customs G. Mumbai 2005 187 EL2 3 Mumbai Customs, Excise and Service Tax Appellate Tribunal. Core issues: whether lack of supervision and control over employees by a custom house agent (CHA) justifies revocation of license even without proof of personal knowledge. Whether allegations of receiving commission and failure to verify documents leading to undervaluation were established. Held decision of the tribunal. Revocation of CHA license upheld on ground of lack of supervision. Allegation of commission undervaluation not proved. Key legal findings. 1. Duty of supervision, strict responsibility. Enquiry officer found lack of supervision and control by CHA over employees. This amounted to violation of Regulation 14(h) Proper supervision of employees. Regulation 14(j) Due diligence in conduct of business. Tribunal held personal knowledge of CHA is not required to establish violation. CHA is vicariously responsible for acts of employees. 2. Revocation justified even without mens rea. Absence of finding that CHA knowingly participated in misconduct. Does not absolve CHA from regulatory violations. Regulatory framework imposes high standard of care. 3. Undervaluation allegation rejected. Allegation: CHA received commission from employee and failed to verify documents, resulting in undervaluation. Enquiry officer observed invoice value matched bill of entry value. CHA cannot be expected to detect undervaluation in such circumstances. Tribunal held charge not proved. Legal consequence: license revocation sustained based on supervisory lapse. Serious reaffirmation of vicarious liability of CHAs. Not every valuation issue automatically implicates CHA. Statutory provisions involved. Regulations 14(h), 14(j), 27, Custom House Agents Licensing Regulations, 1984. One-line ratio decidendi. A custom house agent's failure to supervise and control employees constitutes a regulatory violation warranting license revocation even without proof of personal knowledge. However, undervaluation cannot be presumed where invoice and declaration values match. Continuing relevance. Though under Chalar 1984, principles continue to apply under CBLR 2013/2018 Due Diligence Employee Supervision. Case law summary. Bombay Shipping Agency versus of COS General Mumbai 2016 366 3 Mumbai Customs, Excise and Service Tax Appellate Tribunal. Core issues: whether filing fresh shipping bills with altered values during investigation amounted to violation of Chalar 2004. Whether failure to verify exporters' antecedents and identity justified revocation of CHA license. Whether permanent revocation was proportionate punishment. Facts in brief. Exporter was under investigation for fraudulent drawback. CHA filed new shipping bills for the same consignment. FOB value and unit price changed. Other particulars retained. Resulted in reduction of drawback. Amendment request submitted to CWC, Custodian and Appraiser. instead of Deputy Assistant Commissioner, the competent authority. Held, decision of the tribunal. Violations of regulations established. Permanent revocation held too harsh. Revocation restricted up to 31st December 2015. Security deposit forfeiture upheld. Key legal findings. 1. Failure to verify exporter, serious lapse. Exporters. Address non-existent but incomplete. Director not traceable. IEC obtained without clean intention. CHA failed in verifying identity and functioning of exporter. Accepting documents through unauthorized representative. Violation of Regulation 13 O. Chalar 2004 clearly established. Though unauthorized amendment employee control. Letter for amendment of shipping bills. Signed by unauthorized person. CHA failed to exercise control over employees. Prevent employees from accepting work from unauthorized persons. Violation of Regulation 19(8) established. 3. Proportionality of punishment. Tribunal held. Misconduct proved, but permanent revocation disproportionate. Modified punishment. License revocation till 31 December 2015. Security deposit forfeited. Statutory provisions involved. Regulation 13 O. Verification of exporter's identity. Regulation 19(8) Control over employees. Regulation B's Punishment. Custom House Agents Licensing Regulations 2004. One-line ratio decidendi. A CHA's failure to verify exporters' antecedents and control employees constitutes serious regulatory violations. However, punishment must be proportionate, and permanent revocation may be reduced where circumstances so warrant. Practical significance. Reinforces KYC and due diligence obligations of CHAs. Emphasizes competent authority for shipping bill amendments. Demonstrates CESTAT's power to modify punishment. Case law summary. Ratnadeep Shipping Pvt. Ltd. versus of Customs General, Mumbai. दो हजार 15 330 ELT 488 Trai, Mumbai. Customs, Excise and Service Tax Appellate Tribunal. Core issues. Whether the CHA aided and abetted the importer in submitting forged fabricated bills of entry and misdeclaration, Regs 13D, 13E, 13I of Chalar 2004. Whether there was negligence of duty on part of the CHA, Reg 13N, and the appropriate punishment. Facts in brief. Importer later forged signatures of customs officers and manipulated description value in documents sent by fax to the CHA after trust had been established. Original and forged documents looked identical at first glance. Discrepancies were detectable only on careful scrutiny. CHA's signature and stamp on the bill of lading was cited by Revenue to allege knowledge abetment. Held, decision of the tribunal. No abetment proved under Regs 13D, 13E, 13I. Negligence proved under Reg 13N. Punishment reduced. Revocation restricted up to 30 November 2015. Security deposit forfeiture reduced to 50%. Key legal findings. 1. No aiding or abetting established. No evidence that Shah knowingly assisted duty evasion. Initially, no misdeclaration by importer. Fraud occurred later via fax documents with minor alterations. Forgery by importer alone cannot, ipso facto, constitute Shah's violation of Reg. 13 I. Hence, Regs 13 D 13 E. Abetment not proved. 2. Negligence under Regulation 13 N proved. Shah failed to carefully compare fax documents with originals received later. Mistakes in description were not corrected, admitted by director. This amounted to negligence due to inadvertence, not gross negligence or misconduct. 3. Proportionality of punishment. Given absence of mens re-abetment and presence of only inadvertent negligence. Permanent revocation unwarranted. Time-bound revocation and partial forfeiture considered just. Statutory provisions involved. Regulations 13 D, 13 E, 13 I, 13 N, Customs House Agents Licensing Regulations, 2004. One-line ratio decidendi. Forgery by an importer does not automatically implicate a Shah in abetment. However, failure to exercise due care in verifying fax documents against originals constitutes negligence under Regulation 13 N, warranting proportionate, not extreme, punishment. Practical takeaways. Abetment requires proof of knowledge intent. Mere presence of Shah stamp signature is insufficient. Document verification controls, fax versus original, are critical to avoid negligence findings. Punishment must be proportionate to the gravity and nature of lapse. Case law summary. DVR Freight Forwarders PVT Ltd versus CC Seaport Import Chennai 2015 325 Infras Mad Dot. High Court of Judicature at Madras. Core issue. Whether the High Court should exercise writ jurisdiction under Article 226 to interfere with an order revoking a customs broker license and forfeiting the full security deposit when the statutory authority has acted within jurisdiction and in accordance with law. Held, decision of the court. Writ petition dismissed. No interference under Article 226 warranted. Revocation and forfeiture order upheld. Key legal findings. 1. Statutory authority acted within jurisdiction. The Commissioner, Appeals, exercised powers under Regulation 27 of the Customs Brokers Licensing Regulations, 2013. The order revoked the customs broker license and forfeited the entire security deposit. Court held that the authority acted within the scope of the regulations and did not exceed jurisdiction. 2. No violation of natural justice. The impugned order was not passed in breach of principles of natural justice. No prejudice was shown to have been caused to the petitioner due to any procedural lapse. 3. Limits of writ jurisdiction under Article 226. The court reiterated settled law that Article 226 is an extraordinary remedy. High courts should interfere only when statutory authority acts contrary to the Act rules, or there is defiance of fundamental judicial procedure, or repealed provisions are invoked, or there is total violation of natural justice causing prejudice. None of these grounds were made out in the present case. Legal consequence. Disciplinary action sustained. Writ remedy declined. Parties relegated to statutory remedies, if any. Statutory provisions involved. Regulation 27, Customs Brokers Licensing Regulations, 2013. Article 226, Constitution of India. One-line ratio decidendi. High courts will not exercise writ jurisdiction under Article 226 to interfere with revocation of a customs broker license when the statutory authority has acted within jurisdiction and in compliance with principles of natural justice. Practical significance. Reinforces judicial restraint in service licensing matters. Emphasizes exhaustion of statutory remedies before invoking writ jurisdiction. Useful authority for revenue to resist writ challenges against valid disciplinary orders. Case law summary. Noble Agency versus Commissioner of Customs, Mumbai, 2002, 142 ELT 84, Trai, Mumbai. Customs, Excise and Service Tax Appellate Tribunal. Then CGAT, West Zonal Bench. Core issues. What constitutes proof of subletting of CHA license? Whether mens rea, intent, is required to impose punishment under Chalar 1984. Whether the tribunal can take a lenient view and restore a license once violations are proved. Held, decision of the tribunal. Subletting of license proved. Revocation of CHA license upheld. Plea for leniency rejected. Key legal findings. 1. Proof of subletting, sufficient evidence. Defense witness admitted that his employer did not hold a CHA license and he was using the noticee's CHA license on payment of monthly sums. Tribunal held such admission is sufficient proof of subletting of license. Violation of Regulation 13 Chalar 1984 established. 2. Subletting is a grave violation. Subletting of license for pecuniary benefit and failure to maintain proper accounts must be viewed seriously as it defeats the licensing system, endangers customs control. Revocation under Regulations 13, 1421 of Chalar 1984 upheld. 3. Mens rea not essential. Tribunal ruled contravention of obligations itself is sufficient to invite punishment. Intent or mens rea is not mandatory. However, deliberate contraventions must be dealt with most seriously. 4. Tribunal's powers are limited. Customs Act 1962 Section 129B. Tribunal is a creature of statute and cannot grant relief beyond statutory powers. Where license revocation is legally ordered, tribunal cannot restore the license on sympathy or leniency. Legal consequence. Subletting firmly established as zero tolerance violation. Revocation sustained without scope for leniency. Reinforces strict compliance culture for CHAs. One-line ratio decidendi. Subletting of a CHA license for pecuniary gain is a serious violation. Proof thereof warrants revocation, and neither absence of mens rea nor plea for leniency can justify restoration by the tribunal. Continuing relevance. Principles squarely applied later by Supreme Court in Kem Ganatra, strict view on subletting. CBLR 2013/2018 jurisprudence. Case Law Summary. Cargo Clear International versus Commissioner of Customs, Cochin. 2008 224 ELT 450 Trai, Bang. Customs, Excise and Service Tax Appellate Tribunal. Core issue: whether withdrawal of a temporary customs house agent (CHA) license was justified when the authorized signatory repeatedly failed to qualify the prescribed examination, and whether a fresh appointment could be permitted after such withdrawal under Chalar 2004. Held, decision of the tribunal. Withdrawal of temporary CHA license upheld. No provision to permit appointment after withdrawal. Action of the department held justified. Key legal findings. 1. Failure to qualify examination is fatal. The authorized signatory failed to clear the examination despite several opportunities. Qualification in the examination is a mandatory requirement to continue as CHA. Continued failure undermines eligibility for holding even a temporary license. 2. No enabling provision for post-withdrawal appointment. Customs House Agents Licensing Regulations 2004 contain no provision allowing appointment of another person after withdrawal of a temporary license. Hence, the plea to regularize by appointing a new signatory was rejected. 3. Regulations applied. Regulation No. Temporary License Framework. Regulation 20. Power to withdraw take action. Department acted within the four corners of the regulations. Legal consequence. Temporary license validly withdrawn. CHA cannot continue operations without meeting examination criteria. No equity-based relief in absence of statutory provision. One-line ratio decidendi. Failure of the authorized signatory to qualify the prescribed examination despite repeated chances justifies withdrawal of a temporary CHA license, and in absence of an enabling provision, no fresh appointment can be permitted thereafter. Practical significance. Highlights strict compliance with qualification requirements. Reinforces that licensing is statutory, not equitable. Useful precedent where CHAs seek post-withdrawal regularization. Case Law Summary. Union of India versus Shashi Diojha 1999 113 EL 85 Call. High Court at Calcutta. Core issues. Nature of appeal proceedings under the Customs Act Central Excise Act. Scope and limits of discretionary powers exercised by customs authorities. Legality and duration of suspension of a customs house agent CHA license. Maintainability and scope of writ jurisdiction under Article 226. Held, decision of the court. Suspension of CHA license cannot be indefinite. Reasons for immediate suspension must be recorded. Inquiry must follow suspension within a reasonable time. Writ jurisdiction can be exercised despite alternative remedy in exceptional cases. Key legal findings. 1. Appeal is continuation of original proceedings. The court reiterated a settled principle. An appeal is a continuation of the original proceedings. Applied to Sections 128(1)(29)A Customs Act 1962. Sections 35(35)B Central Excise Act 1944. 2. Discretionary power must be exercised reasonably. Powers under Sections 122(1)(46)A Customs Act 1962. Section 33, Central Excise Act, 1944. Must be exercised on sound legal principles, reasonably, not arbitrarily, whimsically, or capriciously. 3. Immediate suspension requires recorded reasons. Under Regulation 21(2) of Chalar, 1984, authority must record reasons justifying expediency of suspending the license immediately. Absence of such reasoning would vitiate the action. 4. Suspension cannot be indefinite. Court strongly held indefinite suspension affects the livelihood of a cha. In this case, suspension continued for 8 months without inquiry. Direction issued. Inquiry proceedings must be initiated within 1 month, failing which, suspension shall stand revoked automatically. Authority cannot punish a cha indirectly by prolonged suspension what it cannot do directly by revocation without inquiry. 5. Writ jurisdiction alternative remedy. General rule. Writ jurisdiction not exercised when alternative remedy exists. However, 3 well-recognized exceptions apply. Violation of fundamental rights. Breach of principles of natural justice. Order passed without jurisdiction or challenge to veers of statute. Since jurisdiction of the Commissioner was challenged and matter was already heard on merits, Court held it was improper to relegate petitioner to alternative remedy at appellate writ stage. 6. Limits on judicial interference. High Court may interfere under Article 226 if order is wholly unreasonable or irrational. But if the order is partly sustainable on valid material, interference is not warranted. Statutory provisions involved. Regulation 21(2) Customs House Agents Licensing Regulations, 1984. Sections 122, 128, 129A, 146A Customs Act, 1962. Sections 33, 35, 35B Central Excise Act, 1944. Article 226 Constitution of India. One-line ratio decidendi. Suspension of a cha license must be supported by recorded reasons, cannot be continued indefinitely without inquiry, and writ jurisdiction may be exercised in exceptional cases notwithstanding availability of alternative remedy. Importance of the judgment. Early and authoritative ruling on livelihood protection of chas. Limits of suspension powers. Forms the foundation for later jurisprudence on time-bound disciplinary action. Abuse of preventive suspension powers. If you want, I can now integrate this judgment into a master comparative chart of all 15 cases. Prepare a suspension versus revocation jurisprudence note. Draft ready-made arguments citing Shashi Dio Jha for cha defense. Summarize article to 26 principles applicable to customs matters. Case law summary. Interport Impex PVT Ltd versus Commissioner of Customs, Mumbai, 1999, 107, ELT 36, Tri-Dot. Customs, Excise and Service Tax Appellate Tribunal. Then CGAT, West Zonal Bench. Core issue. Whether suspension of a custom house agent, cha, license under Regulation 21(2) of Chalar, 1984 was justified solely on the ground of fraud committed by an employee in the absence of any evidence against the Cha firm, its directors, or other employees. Held, decision of the tribunal. Suspension of Cha license set aside. Invocation of Regulation 21(2) held unjustified. Lack of supervision alone not sufficient for immediate suspension. Key legal findings. 1. Employee fraud alone does not justify suspension. Fraudulent refund was obtained by an employee of the Cha. Tribunal found no evidence of involvement of any director or any other employee of the Cha firm. The Cha dismissed the erring employee and informed customs authorities promptly. 2. Lack of supervision ground for immediate suspension. Even if the Cha failed to exercise proper supervision under Regulation 20(7), that by itself is not sufficient to invoke emergency suspension. Such lapse may justify regular inquiry, but not immediate stoppage of business. 3. Scope of Regulation 21(2) strictly construed. Regulation 21(2) immediate suspension is to be used only when it is necessary to immediately stop functioning of a Cha to safeguard the interest of customs. This provision dispenses with prior hearing due to urgency. Tribunal held no such urgency or emergent situation existed in the present case. 4. Absence of material showing urgency. Fraud came to customs notice in October 1998. Employee dismissed and customs informed by December 1998. Despite this, no material shown to justify sudden invocation of Regulation 21(2). Hence, action was arbitrary. Legal consequence. Emergency suspension quashed. Cha license restored. Reinforces strict limits on use of preventive suspension powers. Statutory provisions involved. Regulation 20(7) Supervision over employees. Regulation 21(2) Immediate suspension without prior hearing. Custom House Agents Licensing Regulations 1984. One-line ratio decidendi. Fraud committed by an employee without evidence of involvement of the Cha or its directors and mere lack of supervision under Regulation 20(7) do not justify invocation of emergency suspension powers under Regulation 21(2) of Chalar 1984. Practical significance. Strong defense precedent where employee misconduct is isolated and Cha has taken corrective action. Draws a clear line between regular inquiry and emergency suspension. Complements later rulings Shashi Diojha, United Customs House Agency, on limits of suspension powers. If you want, I can now integrate this as case number 16 in a master consolidated chart. Prepare a suspension versus emergency action comparison. Draft a defense argument citing Interport Impex. Case law summary. Eagle Transport Services versus Commissioner of Customs, Mumbai 1997-96 ELT 469 Tri-Dot. Customs, Excise and Service Tax Appellate Tribunal. Then CGAT, West Zonal Bench. Core issues. Whether subletting transfer of Cha license in substance, though not in name, was proved. Whether handing over signed blank shipping bills and falsely projecting outsiders as employees justified cancellation of license. Nature and professional responsibility of a custom house agent under Chalar 1984. Held decision of the tribunal. Cancellation of CHA license upheld. Charges of subletting and gross misconduct proved. No interference warranted. Key legal findings. 1. Subletting proved beyond doubt. CHA falsely represented employees of a shipping company as his own employees to obtain customs passes. Proprietor admitted. Customs passes issued for employees of Amol Shipping Agency and over 100 signed but blank shipping bill forms were handed over. Tribunal held. This amounted to transfer of license in all but name. Argument that there was no legal transfer was rejected as simplistic and misleading. 2. Signed blank documents grave misconduct. Knowingly handing over signed blank shipping bills enables large-scale misuse and fraud. Shows complete abdication of statutory responsibility. Such conduct renders the CHA unfit to carry on business. 3. Strict view on fitness to hold CHA license. Tribunal agreed with the Commissioner that a person who knowingly facilitates misuse of customs documents cannot be trusted with the responsibilities of a CHA. Earlier tribunal decision cited by appellant was distinguished. 4. Status and role of a CHA, authoritative exposition. The tribunal made important observations on the professional stature of a CHA. A CHA performs specialized functions involving complex customs laws and procedures, makes crucial representations regarding value, description, prohibition, etc., is comparable to professionals like advocates or chartered accountants. Negligence or dishonesty by a CHA can cause serious revenue loss and facilitate import-export of prohibited goods. Hence, high standards of integrity, competence, and conduct are mandatory. Statutory provisions involved. Regulation 21, cancellation bata suspension. Regulations 1314, B, obligations of CHA. Customs House Agents Licensing Regulations 1984. One-line ratio decidendi. Handing over signed blank customs documents and falsely projecting outsiders as employees amounts to subletting and transfer of a CHA license in substance, warranting cancellation. A CHA holds a position of high professional trust requiring strict integrity. Importance continuing relevance. One of the earliest and strongest rulings on subletting of CHA license. Professional accountability of CHAs. Frequently relied upon in later subletting cases, Noble Agency, K.M. Ganatra. Interpreting zero tolerance approach under CBLR 2013/2018. Case law summary. Welcome AIR Express PVT Ltd versus of CUS Airport Administration 2022-344 Call. High Court at Calcutta. Core issues. Whether a customs house agent, CHA, can rely on a let export order, LEO, to dilute statutory obligations under Chalar 2004. Whether allowing a freight forwarder to use the CHA license and authorizing non-approved persons for dock work amounts to grave misconduct. Whether dropping penalty proceedings under the Customs Act affects license revocation under Chalar. Held decision of the court. Revocation of CHA license and forfeiture of security deposit upheld. Leo does not waive CHA's statutory duties. Contraventions under Chalar are independent of Customs Act penalties. Key legal findings. 1. Leo does not dilute CHA obligations. The court held that issuance of let export order by customs cannot waive or dilute the CHA's obligations under Chalar, 2004. Compliance duties continue irrespective of Leo. 2. Use of license by freight forwarder proved. The export job was sourced from a freight forwarder, not directly from the exporter. The appellant failed to verify antecedents of the declared exporter. The appellant allowed the freight forwarder to use its CHA license for financial consideration, a serious violation. 3. Non-approved persons performing CHA functions. The person who actually performed dock clearance, jetty circa, was not an employee of the appellant. The appellant authorized 3 employees of the freight forwarder to obtain jetty circa licenses. None of these persons was approved by customs authorities. This amounted to abdication of CHA responsibilities and effective subletting. CHAR. Statements and retraction. The managing director's statement was not retracted at the earliest. Later retraction was treated as an afterthought. 5. Violations established under Chalar, 2004. Regulation 13(b) Failure to verify Exporter Act with due diligence. Regulation 19 Misconduct warranting revocation. The court reiterated that mens rea is not required. Any contravention of CHA obligations, even without intent, invites prescribed punishment. 6. Chalar is a special law, independent of Customs Act penalties. Dropping of penalty proceedings under the Customs Act does not impact disciplinary action under Chalar. The appellant was not fully exonerated even under the Customs Act. In any event, license action under Chalar stands on its own footing. Legal consequence. License revocation confirmed. Security deposit forfeiture confirmed. Strong reaffirmation of zero tolerance for license misuse and non-approved personnel. One-line ratio decidendi. Let export order does not dilute a CHA's statutory obligations. Permitting a freight forwarder to use the CHA license and engaging non-approved persons constitute grave violations warranting revocation, irrespective of Customs Act penalty outcomes. Practical takeaways. Never outsource or share CHA functions with freight forwarders or unapproved persons. Verify exporter antecedents and source jobs directly. Chalar discipline is independent of outcomes under the Customs Act. Case law summary. Info Capital Logistic Co. versus Commissioner of Customs, New Delhi. 2022 3 Dale Dot. Customs, Excise and Service Tax Appellate Tribunal. Core issues. Extent of KYC and due diligence obligations of a customs broker and freight forwarder. Whether negligence, without profit or mens rea, can still attract penalty under Section 114 of the Customs Act 1962. Quantum of penalty where facilitation is established, but no direct gain is proved. Held, decision of the tribunal. Liability of customs broker and freight forwarders upheld. Negligence and facilitation of prohibited exports established. Penalty sustained but quantum reduced. Key legal findings. 1. Strict KYC obligation on customs broker. A customs broker is duty-bound to verify antecedents and genuineness of the IEC. Identity of exporter. Functioning of exporter at declared address. Verification must be done using reliable, independent, and authentic documents data. In this case, broker never met the exporter but a IEC holder. Failed to verify the source of prohibited goods. Such failure facilitated attempted export of prohibited goods. Though pattern of negligence matters, Tribunal noted that about 8 consignments had been facilitated in the recent past. These were reasonably believed to contain prohibited goods. This showed systemic negligence, not an isolated lapse. 3. Role of freight forwarders clarified. Freight forwarders acted as facilitators and as agents, directly or indirectly, of the customs broker. Tribunal held freight forwarders are also bound by KYC norms. They must assist the customs broker in fulfilling obligations under Customs Broker Licensing Regulations 2013. 4. Mens re profit not essential for penalty. Appellants argued no profit sharing or gain from prohibited exports. Tribunal accepted. They acted on normal remuneration basis. However, held absence of profit or intent does not wipe out liability when negligence facilitates prohibited exports. 5. Penalty reduced on proportionality. Considering no direct profit, no ownership of goods, role limited to facilitation, Tribunal exercised discretion to reduce the quantum of penalty while maintaining liability. Statutory provisions involved. Section 114 Customs Act 1962, Customs Broker Licensing Regulations 2013, KYC Due Diligence Obligations. One-line ratio decidendi. Failure of a customs broker and freight forwarder to verify exporter credentials and antecedents constitutes actionable negligence facilitating export of prohibited goods, attracting penalty under Section 114, though absence of profit may justify reduction in quantum. Practical significance. Reinforces zero-tolerance approach to KYC lapses. Extends compliance responsibility to freight forwarders, not just licensed brokers. Shows that penalty can be mitigated, but liability cannot be avoided even without mens re. Case law summary. Freight logistics versus of CUS Airport General, New Delhi 2022 319 3 Dale. Customs, Excise and Service Tax Appellate Tribunal. Core issues. Whether suspension of customs broker license under Regulation 16 of CBLR 2018 was justified on facts. Whether there was delay in taking suspension action. Whether reasons for immediate action must be recorded again at the stage of confirmation of suspension. Facts in brief. Attempted smuggling of fabric used for making masks to China misdeclared as packing material. IEC of another company was used without its knowledge or involvement. After investigation, show cause notice was issued in the main smuggling case. Appellant customs broker was made connoisseur with penalties proposed. License suspended within 1 week of issuance of SCN and confirmed within 8 days thereafter. Held decision of the tribunal. Suspension and confirmation of license upheld. No inordinate delay in taking action. Recording of reasons once is sufficient. Key legal findings. 1. Suspension requires prima facie satisfaction. Suspension under Regulation 16(1) is justified only where immediate action is required. Such assessment must be based on a prima facie view of the customs broker's role. In this case, investigation had already revealed sufficient material. Broker was made connoisseur in the main offence. Hence, prima facie involvement existed. 2. No delay in invoking suspension powers. Tribunal rejected the plea of delay. Investigation completed. SCN issued. Suspension ordered within 1 week. Confirmation followed within 8 days. Held that this sequence cannot be termed as delayed or arbitrary. 3. Reasons need not be repeated at confirmation stage. Reasons for immediate suspension were already recorded under Regulation 16. 1. Tribunal held. There is no requirement to re-record the same reasons while confirming suspension under Regulation 16. 2. Confirmation order was found to be fair, reasonable, and legally sound. Statutory provisions involved. Regulation 16. 1. 16. 2. Customs Broker Licensing Regulations, 2018. One-line ratio decidendi. Where investigation reveals prima facie involvement of a customs broker in attempted smuggling, suspension of license under Regulation 16 of CBLR 2018 is justified. Reasons recorded at the initial stage need not be reiterated while confirming suspension, and prompt action negates any plea of delay. Practical significance. Clarifies how and when immediate suspension can be invoked under CBLR 2018. Establishes that confirmation of suspension is not a fresh decision requiring fresh reasons. Useful precedent for revenue in defending prompt suspension actions, and for brokers to understand threshold of prima facie involvement. Case law summary. Orient Clearing Forwarding Agency versus Union of India 2001 136 EL 3 Call. High Court at Calcutta. Core issue. Interpretation and scope of immediate action for suspension of a Customs House agent (CHA) license under Regulation 21(2) of the Customs House Agents Licensing Regulations 1984, Chalar 1984, and whether such suspension violates principles of natural justice. Held. Decision of the Court. Suspension under Regulation 21(2) upheld. Immediate action valid when taken after prima facie investigation. No arbitrariness or violation of natural justice. Key legal findings. 1. Meaning of immediate action. The court clarified that immediate action does not mean action must be taken the very moment goods are imported. Can be taken immediately after completion of a prima facie investigation. Time consumed in investigation does not dilute the immediacy of action once the authority forms a prima facie view. 2. Scope of Regulation 21(2) broad and contextual. Regulation 21(2) cannot be read rigidly or mechanically. The phrase immediate action must be read along with. Notwithstanding. In appropriate cases. When an inquiry is pending or contemplated. These expressions expand the scope and allow suspension during pendency of inquiry, not only at its inception. 3. No arbitrariness, limited judicial interference. Where wide statutory power is not misused and suspension is ordered on objective satisfaction for immediate action. The court held that it is debarred from interfering under writ jurisdiction. 4. Natural justice not violated. Suspension under Regulation 21(2) is not equivalent to blacklisting or permanent ban, is a temporary preventive measure, not a final adjudication. In the present case, elaborate hearing was afforded and no final adjudication had yet taken place. Hence, principles of natural justice were not violated. 5. Immediate does not freeze time. The court emphasized, the word immediate does not mean the authority is barred from acting while inquiry is ongoing. Time does not stop running merely because the inquiry has commenced. Statutory provision involved. Regulation 21(2) Customs House Agents Licensing Regulations 1984. One-line ratio decidendi. Immediate action under Regulation 21(2) of Chalar 1984 permits suspension of a CHA license after completion of a prima facie investigation and during pendency or contemplation of inquiry. Such action is neither arbitrary nor violative of natural justice when exercised reasonably. Importance of the judgment. Foundational authority on preventive suspension powers. Interpretation of immediate action. Frequently relied upon by revenue to justify. Suspension post-investigation but before final adjudication. Complements later Calcutta High Court rulings, Shashi Diojha, Asian Freight. If you want next, I can. Add this case into a master consolidated chart, chronological regulation-wise. Prepare a comparative note on immediate action jurisprudence, Chalar CBLR. Draft ready-made arguments, Revenue CHA, on suspension powers. Case law summary. DS Cargo Agency versus of COS Airport General, New Delhi 2020 371 ELT 611 Trai, Dale. Customs, Excise and Service Tax Appellate Tribunal. Core issues. Limitation under Regulation Bs 1 of CBLR 2013. Whether the requirement is to issue the show cause notice SCN within 90 days or to issue and serve it within 90 days. Whether the 90-day time limit is mandatory or directory. Proper statutory interpretation of the word issue. Held, decision of the tribunal. SCN must be issued within 90 days of receipt of offence report. Service within 90 days is not required. Issuance and service are distinct events. Issuance must precede service. In absence of express statutory consequence, the time limit is directory, not mandatory. Noted conflicting coordinate bench views, indicated the need for reference to a larger bench. Key legal findings. 1. Issue serve. The tribunal held that issuance of an SCN is a separate and earlier event than service. No notice can be served unless it is first issued by the competent authority. Regulation 21 requires issuance within 90 days. It does not mandate service within the same 90 days. 2. Directory nature of the 90-day limit. Regulation 21 does not prescribe any consequence for failure to meet the 90-day period. Applying settled principles, where no consequence is stipulated, the provision is directory. The tribunal emphasized that where there is no apparent or intentional delay by the department and the noticee has committed violations, proceedings should not fail on technicalities. 3. Conflicting views, larger bench reference. The tribunal acknowledged a contrary view by a coordinate bench, e.g., RP Cargo. Proposed reference questions. whether the word issue in Regulation 20(1) includes serve, whether the 90-day limit is mandatory or directory. 4. Principles of statutory interpretation. Legislative intent must be gathered from the statute as a whole. General words should receive their natural, wide meaning unless the statute indicates otherwise or such meaning leads to absurd results. Ejusdem generis applies only where the statute clearly warrants it. Statutory provision involved. Regulation 20(1) Customs Brokers Licensing Regulations 2013. One-line ratio decidendi. Under Regulation 20(1) of CBLR 2013, a show cause notice must be issued within 90 days of receipt of the offence report. Issuance precedes service. Service need not be within 90 days, and the time limit is directory in absence of an express statutory consequence. Practical significance. Strong authority for revenue where issuance is timely but service is later. Clarifies the issuance versus service distinction, useful in limitation disputes. Highlights ongoing jurisprudential divergence, supporting arguments for against larger bench reference. If you want, I can update the master consolidated table, now including this case. Prepare a quick reference note on issue versus service across CBLR cases. Draft ready-made arguments, both sides, on Regulation 20(1) limitation. Case law summary. A.M. Ahmed Co. versus Commissioner of Customs, Imports, Chennai. 2014, 309, ELT 400, Mad. High Court of Judicature at Madras. Core issues. What constitutes an offence report under the Customs House Agents Licensing Regulations, Chalar, 2004? From which date the 90-day limitation period is to be calculated for initiating revocation proceedings. Whether revocation of customs broker license and forfeiture of security was justified when the importer settled the case before the Settlement Commission. Scope of writ jurisdiction under Article 226 in license revocation matters. Held, decision of the court. Revocation proceedings quashed as time barred. Revocation and forfeiture also set aside on grounds of fairness and livelihood. Writ jurisdiction validly exercised. Key legal findings. 1. Meaning of offence report clarified. The expression offence report is not defined in the regulations. The court held. Any report or communication indicating the existence of ingredients under Regulation 20(1) misconduct, violation, etc. must be treated as an offence report. Date of knowledge of the Commissioner through any such communication is to be treated as the date of receipt of offence report. 2. Calculation of 90-day limitation period. Under Regulation 22(1) of Chalar, 2004, the Commissioner must issue a notice within 90 days from receipt of offence report. The court emphasized. The regulations prescribe a strict time schedule, not only for commencement but also for conclusion of proceedings. On facts, show cause notice dated 8th May 2010, copy marked to the Commissioner, was treated as the offence report. The 90-day period commenced from that date. Proceedings were initiated beyond 90 days. Hence, entire proceedings were held time-barred and set aside. 3. Revocation unfair when importers settle the case. Basis of revocation. Misdeclaration of country of origin and undervaluation. Importer had made true and full disclosure before the Settlement Commission and settled the matter. Court held. Revocation would throw the customs broker out of business permanently, affecting livelihood. Once the importer escaped penal consequences through settlement, it would be unfair and disproportionate to impose the extreme penalty of license revocation on the broker. Hence, revocation and forfeiture of security deposit was set aside. 4. Exercise of writ jurisdiction justified. Though alternative remedies existed, the court exercised Article 226 because proceedings were clearly time-barred and extreme punishment caused grave prejudice to livelihood. Statutory provisions involved Regulations 2022 Customs House Agents Licensing Regulations 2004, Regulation 27 Customs Brokers Licensing Regulations 2013, Regulations 9, 1, 13, B, 13, D, 13, E, Chalar 2004, Sections 112A, 114A Customs Act 1962, Section 146, 2 Customs Act 1962, Article 226 Constitution of India. One-line ratio decidendi. For purposes of limitation under Chalar, the date on which the Commissioner gains knowledge of the offence through any communication constitutes the offence report. Proceedings initiated beyond 90 days are invalid, and revocation of a broker's license is disproportionate where the importer has settled the case, affecting the broker's livelihood. Practical importance. Strong authority for customs brokers on limitation issues. Clarifies what triggers the 90-day clock. Introduces equitable considerations of livelihood in license revocation. Often cited in Madras High Court jurisdiction against delayed proceedings. If you want, I can now add this case to the master consolidated chart, all cases till now. Prepare a dedicated note on offence report limitation jurisprudence. Compare this case with KTR Logistics and Unison Clearing. Case law summary. Tradewings Logistics India PVT Ltd versus of CUS. Chinnate 2019 370 1910 Trai, Chennai. Customs, Excise and Service Tax Appellate Tribunal. Core issues. Whether suspension of customs broker license was justified when the broker was not directly involved in import of undeclared goods. Whether KYC norms under Regulations 11A, 11M of CBLR 2013 mandate direct collection of documents from the importer. Whether prolonged suspension without completing revocation proceedings is permissible. Held, decision of the tribunal. Continuation of suspension set aside. Regulation 19(2) cannot be used to impose indefinite suspension. Time limits under Regulation 22 must be adhered to. Key legal findings. 1. KYC obligations, no requirement of direct collection. Regulations 11A, 11M, CBLR 2013 require a customs broker to comply with KYC norms, but do not specifically mandate that KYC documents must be collected directly from the importer. Tribunal noted, there was no allegation that the broker fabricated or ignored KYC documents. Merely not collecting KYC documents personally from the importer does not amount to violation. 2. No active role in misdeclaration. Department did not allege any active role of the customs broker in import of undeclared goods or misdeclaration by importer. Suspension cannot be sustained in absence of prima facie involvement. 3. Suspension cannot become a substitute for revocation. Though show cause notice was issued, revocation proceedings were not concluded even after 9 months. Tribunal strongly held. Regulation 19(2) suspension cannot be used indefinitely to achieve the effect of revocation. Such prolonged suspension seriously affects livelihood of the customs broker. 4. Time limit under Regulation 22 is mandatory in spirit. The tribunal emphasized. Regulation 22 prescribes a clear timeline for completion of proceedings. Failure to adhere to timelines renders continuation of suspension illegal and unjustified. Legal consequence. Order continuing suspension quashed. License restored. Revenue directed to follow time-bound disciplinary mechanism. Statutory provisions involved. Regulation 11A, 11M, KYC obligations. Regulation 19(2), suspension of license. Regulation 22, procedure time limit. Customs brokers licensing regulations, 2013. One-line ratio decidendi. A customs broker's license cannot be kept under prolonged suspension in absence of proven involvement, and Regulation 19(2) of CBLR 2013 cannot be misused to impose an indefinite suspension bypassing the time limit prescribed under Regulation 22. Practical importance. Strong authority against indefinite suspension. Clarifies scope of KYC compliance under CBLR 2013. Useful defense precedent where revocation proceedings are delayed. If you want, I can now update a master consolidated table, cases 124. Prepare a one-page note on suspension versus revocation jurisprudence. Draft ready-to-use arguments for customs brokers on prolonged suspension. Case law summary. Syed Jamil Uddin versus Commissioner of Customs, Hyderabad, 2019 369 ELT 1053 TRI HYD. Customs, Excise and Service Tax Appellate Tribunal. Core issues. Whether subletting of customs broker license was proved on facts. Whether failure to verify antecedents of exporters and lack of supervision warranted revocation and forfeiture. Appropriate quantum of punishment under the Customs Brokers Licensing Regulations 2013, CBLR 2013. Facts in brief. SCN alleged license was sublet to Shri Uma Mahesh, managing partner of Vidi Logistics, for 25,000 rupees per month. Violations of CBLR 2013 for non-verification of exporters' antecedents. Assessee contended. Statement of Shri Uma Mahesh was obtained under duress. Shipping bills were filed after verifying IEC with DGFT, addresses and CST numbers. Held decision of the tribunal. Revocation and forfeiture set aside. Penalty of 50,000 rupees imposed. License ordered to be restored forthwith upon payment of penalty. Key legal findings. 1. Subletting allegation, benefit of doubt. Statement of Shri Uma Mahesh. Initially not retracted, later retracted during cross-examination. Bank transfers of 25,000 month corroborated monetary flow. Tribunal observed. Upon retraction, Further probing by department, confrontation with bank transfers was warranted. Benefit of doubt granted to assessee that shipping bills were filed using services of Shri Uma Mahesh rather than clear subletting. 2. Clear violations of due diligence supervision. Despite benefit of doubt on subletting, tribunal held. Regulation 11A violated failure to verify antecedents existence of exporters. Regulation 17A violated failure to properly supervise employees' operations. Verification limited to IEC DGFT checks alone was insufficient in the facts. 3. Proportionality of punishment. Considering nature of lapses, negligence versus proven subletting. Evidence on record. Tribunal held 50,000 rupee penalty under Regulation 22 to be adequate. Extreme penalties, revocation forfeiture, were disproportionate. Statutory provisions involved. Regulations 10, 11A, 17A, 1822 Customs Brokers Licensing Regulations, 2013. One-line ratio decidendi. Where subletting is not conclusively proved, but negligence in verifying exporters and supervising operations is established, a proportionate monetary penalty suffices. License revocation and forfeiture are unwarranted. Practical takeaways. KYC verification must extend beyond mere IEC checks where circumstances demand deeper diligence. Department must corroborate retracted statements with objective evidence. Punishment must be proportionate. Negligence may justify penalty, not automatic revocation. If you want, I can. Add this to a master consolidated table, all cases so far. Prepare a KYC supervision compliance checklist under CBLR 2013. Draft defense versus revenue arguments on subletting versus negligence. Case law summary. KV Prabhakaran versus Commissioner of Customs, Chennai 2019 365 Mad. High Court of Judicature at Madras. Core issue. Whether penalty under Section 114 of the Customs Act 1960 can be validly imposed on a customs broker for misuse lending of CHA license that facilitated an attempt to smuggle prohibited goods, even where the broker claims lack of detailed knowledge of the importer or goods. Held. Decision of the court. Penalty of 5 Rupaye lakhs upheld. Order sustained. Substantial questions of law answered in favor of revenue. Key legal findings. 1. Lending CHA license is a grave misconduct. The assessee lent the CHA license to a third party without knowing the actual importer or verifying the nature of goods. The court held this attitude to be serious and culpable, as it abets stakeholders in attempts to smuggle prohibited goods. 2. Section 114. Penalty justified despite claimed ignorance. Section 114 penalizes acts omissions that render goods liable to confiscation. The court ruled that claimed ignorance does not absolve liability when the broker's conduct facilitates smuggling. Mens rea profit is not essential where facilitation abetment is established. 3. Proportionality of penalty. Considering the nature and gravity of the omissions and commissions, the penalty of 5 lakhs rupees was held neither excessive nor arbitrary. Revenue's action was found reasonable and proportionate. Statutory provision involved. Section 114 Customs Act 1962. One-line ratio decidendi. lending or permitting use of a CHA license without verifying the importer or goods constitutes facilitation of attempted smuggling, justifying imposition of penalty under Section 114 of the Customs Act. A 5 lakh rupees penalty is proportionate to such misconduct. Practical takeaways. Never lend or share a CHA license. This alone can ground severe penalties. Verification duties are non-delegable. Ignorance is no defense where facilitation is proved. Courts will uphold deterrent penalties to protect revenue and border security. If you want, I can. Add this to the master consolidated chart, chronological regulation-wise. Compare Section 114 penalties across similar cases. Draft a compliance checklist to avoid license misuse. Case law summary. RSR forwarders versus Commissioner of Customs, New Delhi, 2018, 364, 141, Trai, Dale. Customs, Excise and Service Tax Appellate Tribunal. Core issues. When does the 90-day limitation period commence for issuing a show cause notice (SCN) under the Customs Broker Licensing Regulations 2013 CBLR 2013? Whether revocation of Customs Broker License was justified where the broker was not directly involved in smuggling but failed in due diligence. Appropriate penalty for regulatory violations. Held decision of the tribunal. SCN held to be within limitation. Revocation set aside. Lesser penalties sustained. Key legal findings. 1. Commencement of 90-day period. Receipt of offence report. The tribunal clarified that the 90-day clock starts only upon receipt of the offence report by the licensing authority, Commissioner. Although contraband, red sanders concealed with non-basmati rice, was detected earlier, 20th August 2014, the Commissioner received the offence report only on 15th December 2016. The SCN issued on 20 August 2017 was therefore within time and not time-barred. 2. Role and duties of a customs broker. The CHA was not directly involved in transporting the prohibited goods. However, the CHA has a significant role in customs procedures and must verify antecedents of the exporter and ensure genuineness of export documents before filing. Failure in these duties constituted violations of CBLR 2013. 3. Proportionality of punishment. While violations were established, they were not so grave as to warrant revocation of the license. Proportionate punishment ordered. Forfeiture of security deposit 75,000 rupees and penalty 50,000 rupees. Statutory framework. Customs Broker Licensing Regulations 2013. Limitation tied to receipt of offence report. Due diligence obligations. One-line ratio decidendi. The 90-day limitation for issuing an SCN under CBLR 2013 begins upon receipt of the offence report by the licensing authority, where due diligence lapses are proved without direct involvement in smuggling. Proportionate penalties rather than license revocation are appropriate. Practical takeaways. Limitation defenses hinge on the date the Commissioner receives the offence report, not the date of detection by investigating agencies. Due diligence is non-negotiable for customs brokers, even absent direct involvement. Punishment must be proportionate to the gravity of violations. If you'd like, I can. Add this to your master consolidated chart, limitation penalty cases. Prepare a quick reference note on offence report jurisprudence. Draft defense arguments where revocation is disproportionate. Case Law Summary. Punia Brothers versus Commissioner of Customs, Preventive, Jodhpur, 2018, 363, Alt 134, Trai, Dale Dot. Customs, Excise and Service Tax Appellate Tribunal. Core issues: whether a customs house agent, CHA, whose license was suspended for misconduct, later revoked subject to penalty, has an automatic rightful claim to renewal on expiry. Whether non-renewal of a license amounts to double jeopardy when disciplinary action has already been taken. Scope and application of Regulation 9, 2, Vis-a-vis Regulations 4-5 of the Customs Brokers Licensing Regulations, 2013, CBLR, 2013. Held, decision of the tribunal. Rejection of renewal application upheld. Non-renewal and revocation are distinct actions. No unfettered right to renewal exists. Key legal findings. 1. No automatic right to renewal. The tribunal rejected the plea that, since the license was not permanently revoked, renewal must follow as a matter of course. Under CBLR 2013, renewal is not automatic. It is conditional upon meeting mandatory criteria. 2. Renewal governed by Regulation 5, not Regulation 4. Renewal may be sought under Regulation 5 with the only relaxation that Regulation 4, fresh grant, does not apply. Conditions A, 2, H of Regulation 5 must still be satisfied at renewal. In this case, conditions D and E relating to conduct fitness were particularly relevant and not satisfied. 3. Non-renewal revocation, no double jeopardy. The tribunal clarified that non-renewal and revocation operate under different provisions and address different stages. Therefore, the plea of being vexed twice for the same allegations was unsustainable. 4. Misconduct findings justified denial of renewal. The prior order, dated 2nd February 2016, recorded complaint of misconduct and presence of mens rea. Given these findings, the Commissioner committed no error in denying renewal under Regulation 9, 2. Statutory provisions involved. Regulation 9, 2. Renewal of license. Regulations 4-5. Eligibility conditions with Reg. 4 not applicable to renewal. Customs Brokers Licensing Regulations 2013. One-line ratio decidendi. Renewal of a customs broker license under CBLR 2013 is not an automatic right. Non-renewal and revocation are distinct, and failure to satisfy mandatory renewal conditions, especially in light of recorded misconduct, validly justifies denial of renewal. Practical takeaways. Compliance and fitness criteria apply at renewal, not just at grant. Past misconduct matters when assessing renewal eligibility. Non-renewal is not punitive duplication of revocation. It is a separate regulatory assessment. If you want, I can. Add this case to your master consolidated table, now including renewal jurisprudence. Prepare a renewal versus revocation comparison note. Draft arguments for against license renewal under CBLR 2013. Case Law Summary. K. Padmanabhan Logistics Pvt. Ltd. versus of CUS. Chinnate 2018 322 Alt 916 Trai, Chennai. Customs, Excise and Service Tax Appellate Tribunal. Core issue: Whether parallel disciplinary action, suspension under Regulation 19 by the parent commissionerate while a prohibition under Regulation 23 was already issued by another customs station for the same act omission or pending inquiry is legal, or whether it amounts to double jeopardy under the Customs Broker Licensing Regulations 2013 CBLR 2013. Held, decision of the tribunal. Parallel action held illegal, double jeopardy. Suspension order set aside. No necessity or justification for suspension once prohibition was in force. Key legal findings. 1. Double jeopardy in regulatory action. Where prohibition, Reg. 23, has already been imposed by the jurisdictional commissionerate for the same alleged misconduct. A further suspension, Reg. 19, by the parent commissionerate for the same cause is impermissible. Such simultaneous actions amount to double jeopardy in substance. Though overkill and paralyzing effect. The combined effect of prohibition at one customs station and suspension across the parent commissionerate paralyzes the customs broker's operations even at stations where no violation was found. The tribunal termed the suspension an overkill and legally unsustainable. 3. Lack of necessity and proportionality. With a prohibition already in place to safeguard revenue, no additional necessity existed for suspension. Regulatory action must be necessary, justified, and proportionate, standards not met here. Statutory provisions involved. Regulation 19, suspension of license. Regulation 23, prohibition from working. Customs Broker Licensing Regulations 2013. One-line ratio decidendi. Imposing suspension under Regulation 19 when a prohibition under Regulation 23 is already in force for the same alleged misconduct constitutes double jeopardy and an overkill, rendering the suspension legally unsustainable. Practical takeaways. Authorities must choose the appropriate measure, prohibition or suspension, not both for the same cause. Proportionality and necessity govern CBLR actions. Strong defense precedent against overlapping, paralyzing regulatory actions. If you want, I can. Add this to the master consolidated chart. Prepare a decision tree when to invoke Reg. 19 versus Reg. 23. Draft defense arguments on double jeopardy under CBLR. Case law summary. Concord Zoom versus Commissioner of Customs C. Chinney 2018 372 Trai, Chennai. Customs, Excise and Service Tax Appellate Tribunal. Core issues. Scope of prohibition under Regulation 23 of CBLR 2013. Whether it can extend to all sections and all commissionerates. Whether continuation of prohibition without following prescribed procedures and timelines is valid. Maintainability of appeal against order of continuation of prohibition. Held, decision of the tribunal. Order of continuation of prohibition set aside. Regulation 23 is only a stopgap interim measure. Prohibition cannot be continued indefinitely or expanded beyond its scope. Key legal findings. 1. Limited scope of prohibition under Regulation 23. Regulation 23 empowers the authority to prohibit a customs broker from functioning only at one or more sections of a customs station. It cannot be extended to all sections of the station or all customs commissionerates. Any such blanket prohibition is beyond jurisdiction. 2. Prohibition is not a substitute for disciplinary proceedings. Regulation 23 is not an alternative to suspension, Reg. 19, or revocation proceedings, Reg. 20. It is only a stopgap arrangement pending initiation of proceedings under other provisions of CBLR 2013. Even revocation, the highest penalty, can be imposed only after following the full procedure and time limits prescribed in the regulations. Therefore, continuing prohibition interminably defeats the statutory scheme. 3. Violation of natural justice and procedural impropriety. Continuation order was passed 4 months after personal hearing without justification. Department claimed exporters failed to appear, but the order itself recorded that exporters' representatives had appeared. Goods were provisionally released, weakening the justification for continued prohibition. These contradictions showed non-application of mind. 4. Continuation order has no independent existence. Tribunal held that the order of continuation of prohibition is only an addendum to the original prohibition order. It does not have an independent existence. Hence, appeal against the continuation order was maintainable. Contention that appeal should have been filed only against the original prohibition order was rejected. Statutory provisions involved. Regulation 23, prohibition from working. Regulation 1920, suspension and revocation. Customs Brokers Licensing Regulations 2013. Section 129A, Customs Act 1962, appeal to tribunal. One-line ratio decidendi. Prohibition under Regulation 23 of CBLR 2013 is only a temporary, station-specific stopgap measure and cannot be continued indefinitely or expanded to paralyze a customs broker's operations without following prescribed procedures and timelines. Practical significance. Strong authority against indefinite or blanket prohibitions. Clarifies that Reg. 23 cannot replace suspension or revocation proceedings. Useful defense precedent where prohibition is misused to stall a broker's livelihood. Case law summary. Blessing Cargo Care Pvt. Ltd. versus Commissioner of Customs, Chinney 8. 2018 361 EL721 Mad. High Court of Judicature at Madras. Affirmed in 2000 Mad. Core issues. Whether suspension of customs broker license under Regulation 19 of CBLR 2013 was justified for misdescription of goods in the bill of entry. Whether there was delay vitiating the action of immediate suspension. Scope of duties of a customs broker regarding classification and description of goods. Held, decision of the court. Suspension of license upheld. No arbitrariness or perversity in the order. No inordinate or unexplained delay. Key legal findings. 1. Misdescription at the behest of importer, serious lapse. The word computer was deliberately added to the description of goods in the bill of entry to wrongly claim duty exemption, violating Section 46(4) of the Customs Act 1962. The petitioner handled multiple consignments for the same importer across various ports, indicating familiarity with the goods and classification. 2. Failure to advise on correct classification. The customs broker is under a statutory obligation to advise the client on correct classification once it has attained finality. Catalog's technical specification sheets submitted through the petitioner did not portray the lead monitor as a computer monitor. Hence, the petitioner failed in obligations under Regulation 11 of CBLR 2013, due diligence, correctness of declarations. 3. Immediate suspension, time aspect justified. Suspension order passed within 3 months of seizure of goods. Statements of Managing Director of the petitioner and Authorized Representative of the importer were recorded after seizure and before suspension. Court held. There was no inordinate or unexplained delay. Case clearly fell within the scope of immediate suspension under Regulation 19(1). 4. Judicial restraint in suspension matters. Suspension was found to be neither perverse nor arbitrary. Preventive action was necessary to protect revenue interests. Statutory provisions involved. Section 46(4) Customs Act 1962. Regulation 11 Duties of Customs Broker. Regulation 19(1) Suspension of License. Customs Brokers Licensing Regulations 2013. One-line ratio decidendi. Where a customs broker facilitates deliberate misdescription of goods to avail ineligible exemption and fails to advise correct classification, suspension of license under Regulation 19(1) of CBLR 2013 is justified, and action taken within a reasonable time cannot be assailed as delayed or arbitrary. Practical significance. Reinforces that classification advice is a core obligation of customs brokers. Establishes that knowledge across multiple consignment ports strengthens the case against the broker. Confirms that reasonable time taken for investigation does not negate immediate action. Case law summary. Cargo Care International versus Commissioner of Customs, Cochin 2008 361 Cardot. High Court of Kerala. Core issue. Whether non-issuance of a written notice within 90 days under Regulation 19(1) of the Customs Brokers Licensing Regulations 2013 CBLR 2013 renders the suspension of a customs broker license invalid on the ground of limitation. Held. Decision of the court. 90-day period under Regulation 19(1) is not a limitation period. Suspension not vitiated for non-compliance with a 90-day timeline. No interference with suspension. Proceedings directed to be completed expeditiously. Key legal findings. 1. Nature of the 90-day requirement under Regulation 19(1). Regulation 19(1) requires issuance of a written notice to the broker within 90 days of receipt of the offence report. However, the regulation does not prescribe any consequence for failure to adhere to this timeline. Though directory, not mandatory. The court held that the 90-day period is not a statutory limitation that nullifies proceedings. In the absence of a penal consequence, the provision must be treated as directory, not mandatory. Hence, subsequent proceedings under Regulations 19 and 20 are not invalidated merely due to delay. 3. judicial restraint and balanced relief. The single judge had declined to interfere with the suspension order, but directed completion of proceedings within 3 months. The division bench found no merit in the appeal against this balanced approach. Statutory provisions involved. Regulation 19(1) Suspension of license. Regulation B's Revocation proceedings. Customs Brokers Licensing Regulations 2013. One-line ratio decidendi. The 90-day period mentioned in Regulation 19(1) of CBLR 2013 is not a limitation period. Absence of a stipulated consequence renders it directory, and suspension proceedings are not invalidated by its non-compliance. Practical significance aligns with Bombay and Calcutta High Court views, treating timelines as directory. Supports Revenue's position where suspension is challenged solely on delay under Regulation 19(1). Reinforces court's preference for expeditious completion over outright quashing on technical grounds. Case law summary. Capricorn Logistics Pvt. Ltd. versus Commissioner of Customs, Bangalore. 2018 360 ELT 497 Kardot. High Court of Karnataka. Core issues. Validity of prohibition from working imposed under Regulation 23 of the Customs Brokers Licensing Regulations 2013 CBLR 2013 as an immediate preventive measure. Alleged breach of natural justice at the stage of prohibition. Maintainability of writ petition under Article 226 when statutory remedies are available. Held, decision of the court. No interference under Article 226. Immediate prohibition upheld as a preventive, interim measure. Writ petition dismissed as premature. Key legal findings. 1. Immediate action under Regulation 23 justified. Authorities are empowered to take immediate action to prevent continuation of illegal activities and secure revenue interests. The prohibition order was operative immediately and until further orders, indicating its temporary and preventive nature pending investigation. 2. Natural justice, post-decisional safeguards sufficient. The court held that the petitioner had an opportunity to show cause and establish compliance before the competent authority. An adequate and efficacious appellate remedy existed before the tribunal under Regulation 21. Allegations of breach of natural justice could be raised before the tribunal, not at this premature writ stage. 3. Gravity of allegations matters. The alleged modus operandi, shell companies, fake export documents, and illegal drawback claims prima facie shock the conscience of the court. In such circumstances, a temporary ban pending investigation, and even a permanent ban, if proved, does not warrant constitutional interference at the threshold. 4. Writ restraint in revenue protection actions. The court emphasized that preventive actions to curb tax evasion and revenue leakage should not be lightly interfered with on technical pleas. Natural justice cannot be used as a shield to protect gross violations resulting in evasion of duties. Statutory provisions involved. Regulation 23, prohibition from working. Regulation 21, appeal. Customs Brokers Licensing Regulations 2013. Article 226, Constitution of India. One-line ratio decidendi. Immediate prohibition under Regulation 23 of CBLR 2013 imposed as a preventive measure to curb serious revenue fraud. does not warrant interference under Article 226 at a premature stage, especially when statutory remedies are available and post-decisional safeguards exist. Practical takeaways. Reg. 23 can be invoked swiftly to prevent ongoing harm. Courts will show writ restraint. Natural justice challenges should ordinarily be pursued via statutory appeal, not writ. In cases involving grave revenue fraud, constitutional courts will avoid early intervention. Case law summary. Navedita Prakash Gawade versus Union of India 2018 360 ELT 81 Bomb dot. High Court of Judicature at Bombay. Affirmed by the Supreme Court 2018 360 ELT SC. Core issue. Whether the benefit of a Customs House agent (CHA) license can be extended to the legal heirs of a license holder after his death, particularly when the license was not operational at the time due to cancellation and pending litigation. Held. Decision of the court. Benefit of CHA license cannot be extended to heirs. Heirs must apply afresh and comply independently with the regulations. Writ jurisdiction cannot be used to revive a non-operative license. Key legal findings. 1. License benefit cannot pass to heirs. Although the tribunal had earlier decided in favor of the license holder and the Supreme Court vacated the stay, the license holder died during pendency of the appeal. The court held. Since the license holder himself could not avail the benefit of the tribunal's order during his lifetime, his heirs cannot claim continuation or revival of that license. Though independent compliance mandatory, Customs broker license is personal and regulatory, not inheritable. Legal heirs must independently satisfy all statutory requirements and apply afresh for a license. The court emphasized strict adherence to Regulation 7 and thus of the CBLR 2013. 3. Limits of writ jurisdiction. The High Court held that, under Article 226, it cannot displace statutory regulations or direct revival of a license that was not in operation or grant equitable relief contrary to the regulatory framework. Statutory provisions involved. Regulation 7 Grant of license. Regulation thus Obligations conditions. Customs brokers licensing regulations 2013. One-line ratio decidendi. A customs broker license is personal and non-inheritable. Legal heirs cannot claim its benefit upon the holder's death and must independently comply with the regulations to obtain a fresh license. Practical takeaways. CHA CB licenses do not devolve by succession. Equitable considerations cannot override statutory licensing requirements. Writ courts will not revive or continue a non-operative license contrary to the regulations. Case law summary. Surpass freight forwarders versus of CUS Import Chennai 2017 358 ELT 726 Trai Chennai. Customs, Excise and Service Tax Appellate Tribunal. Core issues. Whether revocation of a Customs House agent (CHA) license under Regulation Bs of the Customs Brokers Licensing Regulations 2013 CBLR 2013 can be sustained when statutory timelines are not followed. Whether limitation under the regulations can be ignored despite allegations of abetment, use of others' ICs, and undervaluation. Effect of belated action on principles of natural justice. Held decision of the tribunal. Revocation set aside on limitation. Failure to issue notice within prescribed time is fatal. Department lost its remedy under Regulation 20. Key legal findings. 1. Limitation under CBLR cannot be bypassed. Even assuming involvement abetment by the appellant, the tribunal held that statutory limitation cannot be given a go-by. When Customs fails to adhere to the prescribed timelines, it loses the remedy available under Regulation 20. 2. Date of offence report is decisive. Offence report came on record on 7th November 2013. Revocation ordered on 19th January 2015 without issuance of notice within the stipulated period under Regulation 20. Such action was held time-barred. 3. Reliance on A.M. Ahmad Co., Madras HC. The tribunal applied the principles laid down by the Madras High Court in A.M. Ahmad Co., holding that limitation is mandatory in effect where the regulations prescribe a strict time schedule. Non-compliance renders the proceedings invalid. 4. Natural justice violated by belated action. Although proceedings under CBLR are without prejudice to action under the Customs Act 1962, belated initiation and failure to follow due process violated principles of natural justice, making the order fatal. Statutory provisions involved. Regulation B's revocation of license. Customs Brokers Licensing Regulations 2013. Customs Act 1962 without prejudice clause. One-line ratio decidendi. Allegations of serious misconduct do not permit the department to bypass statutory limitation under CBLR 2013. Failure to issue notice within the prescribed time vitiates revocation proceedings and violates natural justice. Practical significance. Strong defense precedent on limitation under CBLR 2013 confirms that serious allegations do not cure procedural illegality. Aligns Chennai bench jurisprudence with Madras High Court on strict adherence to timelines. Case law summary. Makrupa Forwarders Pvt. Ltd. versus Commissioner of CUS G. Mumbai 2017 357 ELT 1017 Trai, Mumbai. Customs, Excise and Service Tax Appellate Tribunal. Core issues. Whether revocation proceedings under the Customs Broker Licensing Regulations 2013 CBLR 2013 become invalid due to extraordinary delay beyond prescribed timelines. Whether time limits under Regulations 20, 1, 20, 5 and 27 are mandatory or directory. Impact of prolonged proceedings on the fundamental right to livelihood. Held decision of the tribunal. Revocation proceedings quashed on limitation alone. Time limits under CBLR 2013 held mandatory. License directed to be restored forthwith. Severe strictures passed against the department. Key legal findings. 1. Exceptional and unexplained delay fatal to proceedings. The prescribed overall time limit under CBLR 2013 is 270 days. In the present case, proceedings continued for nearly 4 times the statutory limit. Such delay was held exceptional, unreasonable, and illegal, vitiating the entire action. Though time limits under CBLR are mandatory, the tribunal categorically held that the word shall used in Regulations 20, 1, 20, 5, and 27 7 is mandatory, not directory. Reasoning. Consequences of inaction are serious. Treating timelines as directory would encourage administrative arbitrariness and aid corrupt practices by keeping brokers under prolonged uncertainty. 3. Reliance on CBEC circular systemic failure exposed. CBEC circular No 92010 Cus. Dated 8 April 2010 mandates strict adherence to timelines. Data placed before the tribunal in Lohia Travels cargo. Not a single case out of 15 complied with prescribed timelines. Several inquiries pending for more than 5 years. This demonstrated systemic non-compliance by the department. 4. Violation of fundamental right to work. Prolonged suspension revocation proceedings. Infringe Article 19, 1, G, right to practice a profession. Tribunal observed. Guilty brokers escape due to delay. Innocent brokers suffer prolonged hardship. In both situations, justice is defeated. 5. Appeal allowed without examining merits. Given the gross violation of mandatory timelines, the tribunal allowed the appeal solely on limitation and did not go into merits of allegations. Statutory provisions involved. Regulations 20, 1, 20, 5, 27, Customs Brokers Licensing Regulations, 2013. CBEC Circular No 92010 Cus. Dated 8 April 2010. Article 19, 1, G, Constitution of India. One-line ratio decidendi. Time limits prescribed under Regulations 20, 1, 20, 5 and 20, 7 of CBLR 2013 are mandatory. Extraordinary delay in completing revocation proceedings vitiates the action and violates the customs broker's fundamental right to livelihood. Practical significance. One of the strongest precedents holding CBLR timelines mandatory. Frequently cited in limitation-based offences. Highlights systemic administrative lapses and judicial intolerance towards prolonged proceedings. Case law summary. See Coral Clearing Forwarding versus comma of CUS. Chinnate 2017 3 ELT 620 Mad. High Court of Judicature at Madras. Core issues. Whether quoting wrong regulations in the suspension order vitiates the action. Whether the suspension was time-barred on the ground of limitation relating to the offence report. Whether the High Court should interfere under Article 226 when alternative remedies exist and the order is a reasoned, discretionary one. Held, decision of the court. Suspension upheld. No limitation bar. Writ jurisdiction declined. Key legal findings. 1. Wrong citation of regulations is immaterial. Though the order referred to Regulations 2022 instead of Regulations 1920 of CBLR 2013, the court held this to be immaterial. The Commissioner had jurisdiction and authority to suspend the license. A mere misquotation does not invalidate an otherwise lawful exercise of power. 2. Limitation. Date of receipt of offence report is decisive. The offence report dated 23 December 2015 by CIU JNCH was not communicated to the respondent commissioner. The first communication referencing the offence report was the Principal Commissioner, Mumbai's order dated 13th April 2016. Hence, The suspension was not hit by limitation. The clock runs from received communication to the licensing authority. 3. Discretion to suspend during pending inquiry. With an inquiry pending, the Commissioner has discretion under Regulation 19 to suspend the license to prevent further misuse and protect revenue interests. The court found no arbitrariness in invoking this preventive power. 4. Writ restraint where remedies exist and order is reasoned. A prohibitory order under Regulation 23 had already been passed by Mumbai Customs with post-decisional hearing. The impugned suspension order was a speaking order with cogent reasons. Therefore, Article 226 should not be invoked. The petitioner must pursue statutory remedies. Reliance placed on Calcutta HC precedent 2016 337 ELT J1 call dot. Statutory provisions involved. Regulation 19 suspension of license. Regulation 20 revocation procedure. Regulation 23 prohibition from working. Customs Brokers Licensing Regulations 2013. Article 226 Constitution of India. One-line ratio decidendi. A suspension order is not vitiated by mere misquotation of regulations. Limitation runs from communication of the offence report to the licensing authority, and where a reasoned, discretionary suspension is passed with alternative remedies available, writ interference is unwarranted. Practical takeaways. Substance over form. Wrong regulation numbers won't undo valid action. Limitation hinges on received communication of the offence report. Writ courts show restraint when preventive suspension is reasoned and remedies exist. Case law summary. Mishra, Agencies, Enterprises versus Union of India 2016 341 EL 307 call dot. High Court at Calcutta. Core issues. Maintainability of a writ petition under Article 226 when an effective alternative statutory remedy exists. Scope of judicial review over a well-reasoned adjudication holding a Customs House agent, CHA, guilty of violation. Whether the High Court can reappreciate evidence or sit as an appellate authority in writ jurisdiction. Held, decision of the court. Writ petition held not maintainable. Petitioner relegated to statutory appeal under Section 129A. No interference where order is reasoned and natural justice complied with. Key legal findings. 1. Alternative remedy, general rule of restraint. The Customs Act 1962 is a complete code providing a specific appellate remedy. An aggrieved must ordinarily exhaust the statutory appeal before invoking Article 226. The availability of an alternative remedy is not an absolute bar, but writ courts impose self-restraint and normally decline interference when the remedy is efficacious. 2. No writ as a substitute for appeal. The impugned order was well reasoned, passed after affording full opportunity, and showed no violation of natural justice. The High Court emphasized it cannot sit in appeal nor assess sufficiency of evidence in writ proceedings. 3. Dismissal even after admission. A writ petition can be dismissed on the ground of alternative remedy even after admission, if the court later finds that statutory remedies were bypassed without justification. Statutory framework precedents. Section 129A, Appeal to the Appellate Tribunal, Customs Act 1962. Regulation 21, Appeals under Customs Brokers Licensing Regulations 2013. Article 226 Constitution of India. Supreme Court precedents relied upon, e.g. 2012, 278, ELT 26, SC, 1998, 8 SCC 1, 2008, 12 SCC 675. One-line ratio decidendi. When the Customs Act provides an efficacious appellate remedy and the impugned order is reasoned and compliant with natural justice, the High Court will not exercise writ jurisdiction to reappreciate evidence. The petitioner must pursue the statutory appeal. Practical takeaways. Choose the right forum. Challenge adverse CHA orders via Section 129 appeal first. Writs are exceptional, not routine, reserved for jurisdictional errors, natural justice breaches, or Veers challenges. Admission of a writ does not guarantee marriage consideration. It may still be dismissed for alternative remedy. Case law summary. Bhaskar Logistic Services Pvt. Ltd. versus Union of India 2016 340 ELT 17 Pat. High Court of Judicature at Patna. Core issues. Whether revocation of customs broker license under CBLR 2013 was valid for KYC failures, misuse of IEC, and lack of supervision. Whether separate license revocation can stand despite non-imposition of penalty in Customs Act confiscation proceedings. Scope of writ jurisdiction where statutory appeal is available and findings are factual. Held. Decision of the court. Revocation of license upheld. No violation of natural justice. Writ jurisdiction declined. Key legal findings. 1. Clear violations of KYC and supervision obligations. The executive director facilitated clearance using the IEC of another person, a grave lapse. Regulations 11 and 11E CBLR 2013 were violated. No verification of antecedents, correctness of IEC, identity, or existence of the client at the declared address using reliable, independent documents. Failure to supervise employees and to exercise due diligence led to misclassification and undervaluation. 2. Proper procedure followed, no natural justice breach. SCN issued, enquiry conducted, and personal hearing granted and availed. Hence, revocation complied with Regulation B's CBLR 2013 and principles of natural justice. 3. License revocation independent of Customs Act penalties. Revocation under CBLR 2013 is separate and independent from penalties under the Customs Act 1962. Non-imposition of penalty in confiscation proceedings does not bar license revocation. 4. IEC compliance emphasized. Import-export must be on one's own PAN-based IEC. Using another's IEC is impermissible. IEC must be correctly reflected in documents and intimated to customs. 5. Writ restraint and scope. High Court's role is to test the decision-making process, not to reappreciate evidence or act as an appellate forum. Where findings are based on evidence and not perverse, Article 226 interference is unwarranted. Since merits were examined and writ dismissed, liberty to pursue alternative remedy was not granted. 6. Strictures on petitioner's conduct. Court deprecated incorrect statements in the writ, misstating resignation facts. No record of mandatory intimation under Regulation 17 CBLR 2013 conduct frowned upon. Statutory provisions involved. Regulations 11E, 11N, 1720 Customs Brokers Licensing Regulations, 2013. Customs Act, 1962. Article 226, Constitution of India. One-line ratio decidendi. Failure to verify IEC and client antecedents, coupled with lack of supervision, justifies revocation of a customs broker license under CBLR 2013. Such revocation is independent of Customs Act penalties, and writ courts will not reappreciate evidence where due process is followed. Practical takeaways. IEC KYC diligence is non-negotiable. Using another's IEC is fatal. License discipline stands independent of confiscation penalties. Accuracy in pleadings matters. Misstatements can attract judicial censure. Case law summary. Aditya Ganguly versus Union of India 2016 337 ELT J1 Call. High Court at Calcutta. Core issues. Whether suspension of a customs broker license under Regulation 19 of CBLR 2013 was invalid for not being taken immediately upon detection. Effect of minor delay in granting post-decisional hearing. Scope of writ jurisdiction when statutory remedies exist. Held, decision of the court. Suspension upheld. Minor delay in post-decisional hearing not fatal. Writ petition dismissed. Alternative remedy to be pursued. Key legal findings. 1. Immediate action assessed from receipt of adjudication order. Suspension was issued on 5th April 2016 based on an adjudication order dated 26th February 2016 received by the licensing authority via forwarding letter dated 17th March 2016. The court held the suspension was not belated. Immediate action must be assessed from when the licensing authority has a concrete basis, here, the adjudication order. Had suspension preceded adjudication on mere knowledge, the broker could allege prejudging. 2. Post-decisional hearing, minor delay not fatal. While timelines should generally be adhered to, a delay of a day or to beyond the 15 days for post-decisional hearing does not render the suspension non-EST. The regulations do not mandate strict, fatal consequences for such minor deviations. 3. Suspension is preventive, not punitive. Suspension is not a punishment. It is a first step potentially leading to revocation, subject to the broker's reply. Mention of contemplation of inquiry does not make the hearing a mere formality. The authority's mind is not closed. 4. Writ restraint where remedies exist. Writ jurisdiction under Article 226 is invocable only if alternative remedy is inefficacious or action is without jurisdiction, baseless, or involves glaring breach of natural justice. None were present. The authority had jurisdiction, the action was reasoned, and post-decisional hearing was granted. Disputed facts and necessity of suspension should be urged in statutory appeal, not writ. Directions. The Principal Commissioner to pass suitable orders within 15 days if the petitioner participated in the post-decisional hearing, otherwise, decide without further opportunity. Writ dismissed with costs, 3,000 rupees. Statutory provisions. Regulation 19, Customs Brokers Licensing Regulations, 2013. Article 226, Constitution of India. One-line ratio decidendi. Suspension under Regulation 19 based on receipt of an adjudication order is not belated. Minor delay in post-decisional hearing is not fatal, and writ jurisdiction will not be exercised where statutory remedies exist and natural justice is complied with. Practical takeaways. Immediate action is judged from the point of reliable basis, not mere detection. Minor procedural delays won't vitiate preventive suspension. Writs are exceptional. Pursue post-decisional hearing and appeal first. Case law summary. Commissioner of Customs, Kandala versus Sarthi Shipping Co. 2016 336 EL103 Gujarat. High Court of Gujarat. Core issues. Whether non-issuance of a suspension continuation order within the prescribed period under Regulation 19(2) of CBLR 2013 leads to automatic lapse of suspension. Whether lapse of suspension bars the department from initiating revocation penalty proceedings under Regulation 20. Interplay between Regulations 19 and 20, suspension versus revocation. Held, decision of the court. No interference with tribunal's order on facts. Suspension treated as lapsed due to inordinate delay. Department free to proceed under Regulation 20 despite lapse. Key legal findings. 1. Continuation order under Regulation 19(2), effect of delay. The tribunal held that the 15-day period from the post-decisional hearing, Reg. 19(2), for issuing a continuation order is mandatory. Failure results in automatic lapse of suspension. In this case, the Commissioner issued the continuation order more than 5 months after the hearing, without assigning reasons, a fatal delay on facts. The High Court kept the question of law open, mandatory versus directory, but declined to interfere given the egregious delay. 2. Lapse of suspension immunity from revocation. Crucially, the court clarified. Lapse of suspension, for want of a timely continuation order, does not debar the department from initiating revocation penalty proceedings under Regulation 20. Regulations do not condition revocation on a subsisting suspension. 3. Suspension versus revocation, distinct remedies. Regulation 19, suspension, is preventive interim. Regulation 20, revocation penalty, is disciplinary final. Even if suspension cannot continue, disciplinary action may proceed independently. Statutory provisions involved. Regulation 19(2), continuation of suspension. Regulation B's, revocation penalty. Customs Brokers Licensing Regulations, 2013. One-line ratio decidendi. Where a suspension continuation order is issued after an inordinate, unexplained delay, the suspension lapses. However, such lapse does not preclude the department from initiating revocation or penalty proceedings under Regulation B's of CBLR 2013. Practical takeaways. Timelines for continuation orders matter. Unexplained delays can collapse suspension. Do not conflate suspension with revocation. Even if suspension lapses, Reg. B's action remains open. On facts, courts may avoid deciding the larger legal question yet uphold relief due to egregious delay. Case law summary. Saro International Freight System versus of CUS. Chinnate 2016 334 EL289 Mad. High Court of Judicature at Madras. Core issues. Scope and nature of Regulation B's CBLR 2013. Whether it gives an independent power to revoke license and impose penalty. Whether time limits prescribed in Regulations 1120 are mandatory or directory. From which date limitation is to be reckoned offence report date of knowledge. Validity of belated show cause notice for revocation. Held, decision of the court. Show cause notice quashed as time barred. Strict adherence to time limits emphasized. Regulation 20 confers independent disciplinary power. Key legal findings. 1. Regulation 20 independent and drastic power. Regulation 20 gives the Commissioner an independent right to initiate action Dehors proceedings under other regulations and the Customs Act 1962. Revocation of license is an extreme step, curtailing the fundamental right to trade profession, Article 19, 1, G. Therefore, timely action is mandatory too. Protect brokers from prolonged uncertainty and enable swift curbing of unlawful activities. Though time limits shall not directory. The court held that shall cannot be read as directory in Regulations 1120. Consequence of action is revocation of license. Treating timelines as directory would breed inaction and corruption. Strict timelines ensure accountability of authorities and swift justice for both revenue and brokers. 3. Date of knowledge starting point. Since offence report is not defined in the regulations, date of knowledge of offence must be taken as the starting point for limitation. No concept of excluding non-working days. Time is counted calendar-wise, except where the last day falls on a holiday. 4. Belated SCN is fatal. In the present case, SCN for revocation was issued after 90 days from date of suspension and date of report knowledge of offence. Such delay violated statutory prescription, rendering the SCN unsustainable. 5. Nature of CBLR 2013. Regulations framed under Section 146, 2 of Customs Act 1962. Though framed under the Act, they operate independently and cannot be treated lightly as subordinate legislation when they affect fundamental rights. Statutory provisions involved. Regulations 1120 Customs Brokers Licensing Regulations 2013. Section 146, 2 Customs Act 1962. Article 19, 1 G Constitution of India. One-line ratio decidendi. Regulation Bs of CBLR 2013 confers an independent and drastic power of license revocation, and the time limits prescribed therein are mandatory. Any show cause notice issued beyond such period from the date of knowledge of offence is unsustainable. Practical significance. Strong Madras High Court authority for mandatory nature of CBLR timelines and quashing revocation proceedings on limitation alone. Frequently cited alongside A.M. Ahmed Co. and KTR Logistics. Useful for defense strategy where SCN is delayed. Case law summary. Burley International versus Commissioner of CUS, Import of General 2016 300 ELT 9 Del Dot. High Court of Delhi. Core issue. Whether the 15-day time limit prescribed under Regulation 19, 2 of the Customs Brokers Licensing Regulations 2013 for passing an order confirming suspension after post-decisional hearing is mandatory, so that non-compliance would automatically invalidate the suspension. Held, decision of the court. 15-day time limit held not mandatory. Suspension not automatically invalid. However, prolonged inaction held unacceptable. Fresh hearing and time-bound decision directed. Key legal findings. 1. 15-day period under Regulation 19(2) is not mandatory. The court held that there is nothing in the regulations to suggest that failure to pass the confirmation order within 15 days would lead to automatic revocation or lapse of suspension. Hence, the petitioner's plea that suspension becomes illegal per se due to delay was rejected. 2. Delay of 5 months cannot be justified. While the time limit is directory, the court emphasized administrative authorities cannot keep matters pending indefinitely. In the present case, no order was passed even after 5 months from the date of hearing. Such prolonged silence was held to be arbitrary and unfair, even if not fatal in law. 3. Balancing approach adopted by the court. Instead of quashing suspension outright, the court adopted a corrective approach. Directed the commissioner to grant a fresh hearing within 2 weeks and pass a reasoned order within the next 2 weeks thereafter. Statutory provision involved. Regulation 19(2) Customs Brokers Licensing Regulations 2013. Article 226 Constitution of India. One-line ratio decidendi. The 15-day time limit under Regulation 19(2) of CBLR 2013 for confirming suspension is directory and not mandatory. However, unexplained and prolonged delay in passing the order is impermissible and warrants judicial directions for expeditious decision. Practical takeaways. Delhi High Court aligns with the directory view on Reg. 19(2) timelines. Even when timelines are directory, authorities must act within a reasonable period. Courts may prefer remedial directions over outright quashing where jurisdiction exists, but administrative lethargy is evident. Comparative note. This case contrasts with Madras HC mandatory view in Saro International, AM Ahmad, KTR Logistics. Aligns more closely with Gujarat HC, Sarthi Shipping, and Calcutta HC approach on directory timelines. Case law summary. United Customs House Agency PVT Ltd versus Union of India 2016 376 Call. High Court at Calcutta. Core issues. Scope of power under Regulation 23 CBLR 2013 to prohibit a customs broker from working. Whether such prohibition can be indefinite permanent without follow-up action. Natural justice requirements, pre-decisional notice versus post-decisional hearing. Maintainability of writ jurisdiction in such circumstances. Held, decision of the court. Prohibition order set aside, on facts, due to indefinite continuation without further action. Revenue at liberty to initiate fresh, appropriate action in accordance with law. Regulation 23 power upheld, but with strict safeguards. Key legal findings. 1. Regulation 23 is an extraordinary, stopgap power. Power to prohibit is exceptional and must be exercised sparingly. It is intended to protect revenue in exigencies, not to replace or bypass. Suspension, Reg. 19 or revocation penalty, Reg. 20. Prohibition cannot be permanent or indefinite. Authorities must move promptly to the appropriate next step. 2. No pre-decisional hearing required in exigency, but safeguards apply. In urgent situations, prior show cause notice or hearing is not mandatory. However, two safeguards are essential: immediate disclosure of reasons for prohibition and post-decisional hearing at the earliest. Compliance with these satisfies natural justice. 3. Indefinite prohibition without follow-up is unlawful. In the instant case, the prohibition order had been in force for several years with no subsequent suspension or revocation proceedings. Such inaction vitiates the prohibition, warranting judicial interference. 4. Precedents depend on reasons, not merely outcomes. What operates as precedent is the reasoning supporting an order, not the order itself. An order cited by the assessee that lacked reasons mandating pre-decisional hearing in every case was distinguishable and not applicable. Statutory provisions. Regulation 23, Prohibition from working. Regulations 1920, Suspension and Revocation Framework. Customs Brokers Licensing Regulations 2013. Article 226, Constitution of India. One-line ratio decidendi. Regulation 23 confers an extraordinary, interim power to prohibit a customs broker in exigent circumstances without prior hearing, subject to immediate disclosure of reasons and post-decisional hearing. Such prohibition cannot be indefinite and must be followed by timely action under Regulations 19 or 20. Practical takeaways. Use Reg. 23 sparingly and temporarily, not as a substitute for formal proceedings. Document reasons immediately and grant post-decisional hearing promptly. Indefinite prohibition invites quashing, though it does not bar fresh lawful action. Case law summary. Masterstroke Freight Forwarders P. Ltd. versus CCI Chennai 2016 300 Mad Dot. High Court of Judicature at Madras. Core issues. Whether the 90-day time limit under Regulation B's 1 of the Customs Brokers Licensing Regulations 2013 CBLR 2013 for issuing a show cause notice SCN is mandatory or directory. From which date the limitation period is to be computed, receipt of offence report versus date of knowledge of offence. Whether delay can be condoned or limitation waived. Maintainability of writ petitions against time-barred SCNs despite alternative remedy. Held, decision of the court. Time limit under Regulation 21 held mandatory. All SCNs issued beyond 90 days quashed. No condonation or waiver of limitation permissible. Writ petitions maintainable. Key legal findings. 1. Regulation 21 time limit is mandatory. The court held that the use of the word shall in Regulation 21 makes the 90-day period mandatory. CBLR 2013 cannot be treated lightly as subordinate legislation, since they operate the Customs Act 1962 and curtail the fundamental right to trade profession Article 19 1G. Purpose of prescribing time limit. to ensure swift action against erring brokers and to prevent administrative lethargy and arbitrariness. 2. Limitation begins from date of knowledge of offence. As offence report is not defined in CBLR 2013, limitation must be computed from the date when the Commissioner gains knowledge of the offence. Department's plea 2. Exclude Saturdays, Sundays, national holidays, or extend time due to requests by brokers. Was rejected. Only exception. If the last day falls on a holiday, it can be excluded. 3. No waiver or condonation of limitation. A broker's request to keep proceedings in abeyance does not amount to waiver of limitation, neither expressed nor implied. The court rejected reliance on Supreme Court precedent to seek condonation of delay. Allowing condonation would defeat the object of CBLR 2013 and open a Pandora's box of stale proceedings. 4. Writ jurisdiction maintainable despite alternate remedy. Though SCNs are ordinarily challenged in statutory appeal, writ jurisdiction is maintainable where notice is issued without authority jurisdiction. Notice is time-barred. Authority has prejudged the issue, or issuance of notice is an abuse of process. In the instant case, SCNs were ex facie barred by limitation, and language of notices showed predetermination. Relegating petitioners to alternate remedy would be futile. Statutory provisions involved. Regulation 21, Customs Brokers Licensing Regulations, 2013. Section 146, 2, Customs Act, 1962. Article 226, Article 19, 1, G, Constitution of India. One-line ratio decidendi. The 90-day time limit prescribed under Regulation B's 1 of CBLR 2013 for issuing a show cause notice is mandatory. Limitation runs from the date of knowledge of offence, cannot be waived or condoned, and any SCN issued beyond such period is without jurisdiction and liable to be quashed in writ proceedings. Practical significance. One of the strongest Madras High Court authorities on mandatory nature of CBLR timelines and writ maintainability against time-barred SCNs. Frequently cited with A.M. Ahmed Co., Saro International, KTR Logistics. Crucial for limitation-based defense in revocation proceedings. Case law summary. Capithan Agencies versus Commissioner of Customs, Chinney 8, 2015, 326, EL 150, Mad. High Court of Judicature at Madras. Core issues. Whether continuation of prohibition under Regulation 23 of CBLR 2013 is valid even after the license issuing commissioner has imposed only a fine without suspension revocation. Scope and object of Regulation 23, prohibition, vis-a-vis disciplinary action under Regulations 1920. Extent of writ interference under Article 26 in matters of proven violations by a customs broker, CHA. Held, decision of the court. Writ petition dismissed. Continuation of prohibition upheld. Action held within the framework of CBLR 2013 and CBEC circular. Key legal findings. 1. Prohibition can continue despite only fine being imposed. The license issuing commissioner imposed only a fine for violations and did not suspend or revoke the license. The CHA accepted the order and paid the fine. The court held that this does not bar the continuation of prohibition under Regulation 23, which operates in a distinct sphere to protect revenue and public interest. 2. Serious and admitted violations justified prohibition. It was undisputed that the CHA allowed unauthorized persons to handle customs clearance and was involved in unauthorized import of drugs and pharmaceuticals. Clear violations established: failure to advise clients properly, failure to verify antecedents of importers, and misuse of the CHA's privileged access to customs. Given the gravity, continuation of prohibition was held reasonable and proportionate. 3. Regulation 23 read with CBEC circular supports continued prohibition. The action was upheld as being within Regulation 23, CBLR 2013 and CBEC circular No 92010 Cus. Dated 8 April 2010. Prohibition is meant to prevent misuse of license and safeguard customs operations, even if disciplinary proceedings result only in a fine. 4. Duties and responsibilities of a customs broker emphasized. The court elaborated on the special status and responsibility of a CHA. CHA is tested by examinations and trusted to assist customs. Must scrutinize documents, advise clients correctly, and prevent illegal activities. CHA must not become an instrument for smuggling or illegal imports. Misuse of CHA position has far-reaching consequences for customs administration. 5. Limited scope of writ jurisdiction. Where violations are established, action is reasoned, and power exercised within regulations. Article 226 cannot be used to dilute regulatory discipline. No arbitrariness or jurisdictional error found. Statutory framework. Regulation 23, prohibition from working as customs broker. Regulations 1920, suspension and revocation framework. Customs Brokers Licensing Regulations 2013. CBEC Circular No 92010 Cus. Dated 8 April 2010. Article 226 Constitution of India. One-line ratio decidendi. Continuation of prohibition under Regulation 23 of CBLR 2013 is valid even where the license issuing authority imposes only a fine and does not suspend or revoke the license when serious violations by the customs broker are established. Practical takeaways. Prohibition, suspension, revocation. Regulation 23 can operate independently to protect revenue. Acceptance of penalty fine does not extinguish the power to prohibit. Courts will strongly emphasize the fiduciary and professional role of CHAs. Writ courts will not interfere where prohibition is justified by admitted or proved misconduct. Case law summary. Chandra CFS Terminal Operators P. Ltd. versus CC Chinneyet 2015 342 Mad Dot. High Court of Judicature at Madras. Core issues. Whether immediate suspension of a CFS license under the handling of cargo in customs areas regulations 2009 HC Car 2009 without pre-decisional hearing violates natural justice. Liability of a CFS for removal of seized goods from custody through Employees Acts. Scope of post-decisional hearing and time-bound completion of proceedings. Held, decision of the court. Suspension of CFS license upheld. Post-decisional hearing held sufficient. Vicarious liability of CFS affirmed. Commissioner directed to conclude proceedings within 3 months. Key legal findings. 1. Immediate suspension justified under HCCAR 2009. A container of seized prohibited goods entrusted to the appellant CFS was removed on bogus documents, allegedly in connivance with CFS staff. Regulation 11 HCCAR 2009 empowers the Commissioner to order immediate suspension where violations occur and inquiry is pending or contemplated. Given the gravity, prior penalties against the appellant, police arrest of employees, and outsourcing security without permission, emergent action was warranted. 2. Natural justice satisfied by post-decisional hearing. The court reiterated settled law. Where urgent preventive action is contemplated, pre-decisional hearing is not mandatory. Post-decisional hearing suffices to meet natural justice in such cases. Importantly, the Commissioner did not bring operations to a complete standstill. The appellant was allowed to handle pending cargo, reflecting proportionality. 3. Vicarious liability of the CFS. The plea of lack of knowledge of employees' illegal acts was rejected. The CFS is vicariously liable for acts done by its employees in the course of employment, a core custodial obligation under HCCAR 2009. 4. Direction for expeditious completion. While sustaining suspension, the court directed the Commissioner to complete investigation and pass final orders within 3 months, uninfluenced by observations in the judgment. Statutory framework. Regulation 1112 Handling of Cargo in Customs Areas Regulations 2009. Customs Act 1962 Contextual Violations. One-line ratio decidendi. Immediate suspension of a CFS license under HCCAR 2009 is valid where serious custodial breaches occur. Pre-decisional hearing is not required in exigent circumstances. Post-decisional hearing satisfies natural justice, and the CFS is vicariously liable for employees' acts. Practical takeaways. Custodians carry strict responsibilities for seized goods. Lapses invite swift action. Emergency powers allow suspension first, hearing later, provided reasons exist. Vicarious liability is a real risk. Controls, permissions, and security oversight must be robust. Authorities should complete proceedings promptly after suspension. Case law summary. International Cargo Agents versus of CUS ST Bangalore 2014 307 EAL 78 Bang. Customs, Excise and Service Tax Appellate Tribunal. Core issues. Whether a customs broker, CHA, whose license was suspended with forfeiture of security can seek restoration without furnishing fresh security under CBLR 2013. Whether additional security of 5 lakhs rupees can be insisted upon when the license was originally issued under earlier regulations. Validity of suspension for non-furnishing of additional security. Role and evidentiary value of CBEC clarifications circulars. Held decision of the tribunal. Requirement to furnish fresh additional security upheld. Suspension for non-furnishing of security held valid. No vested right to continue with old security amount. Appeal rejected on merits with limited early hearing granted. Key legal findings. 1. Security deposit must be available at all times. Though Regulation 7, 8-9 of CBLR 2013 deal with grant renewal of license, the tribunal held. The scheme of CBLR 2013 requires security to be available with the government at all times. If security becomes non-available due to forfeiture or otherwise, the Commissioner is empowered to require fresh security. Though applicability of CBLR 2013 to existing license holders. The CHA argued that since the license was issued under earlier regulations, the old security amount should continue. This plea was rejected. There is no vested or perpetual right to continue with the old security amount. Section 159A of the Customs Act 1962 does not protect a CHA from compliance with new regulatory requirements. Once CBLR 2013 came into force, 5 rupees lakh security became mandatory for restoration. 3. Suspension for non-furnishing of security is valid. Security deposit serves a regulatory and disciplinary purpose. It ensures compliance and provides the government a financial safeguard. Where the statute fixes a specific amount, the CHA cannot argue lack of prejudice to the department. Hence, suspension under Regulation 19 CBLR 2013 for failure to furnish additional security was held proper and legal. 4. No estoppel against law. Even though the suspension order did not expressly state the requirement of 5 lakhs rupees security, this omission was held immaterial. There is no estoppel against statutory requirements. 5. Departmental clarifications, limited value. A CBEC clarification, even if issued as internal correspondence, does not lose validity merely for being internal, is binding on departmental officers, but not binding on SESTAT, which must independently adjudicate. This ensures neutrality and avoids perception of prejudice against the assessee. 6. Early hearing at interim stage. Normally, early hearing is not granted at suspension stage as inquiry must follow. However, early hearing was allowed here because the issue was purely legal and CHA had already suffered 1 month suspension and forfeiture of security. Statutory provisions involved. Regulations 7, 8, 919, Customs Brokers Licensing Regulations, 2013. Section 159 Customs Act, 1962. One-line ratio decidendi. Under CBLR 2013, a customs broker has no vested right to continue with the old security deposit. Where security is forfeited or becomes unavailable, the Commissioner is empowered to insist on fresh security of 5 Rupees lakhs, and suspension for failure to furnish such security is legally valid. Practical takeaways. Security deposit is dynamic, not frozen at the time of original license. Transition to CBLR 2013 applies to all brokers, including legacy license holders. Non-furnishing of prescribed security justifies suspension. CBEC clarifications guide the department, but do not bind adjudicatory forums. Thank you for watching. Subscribe for regular updates and expert content. Knowledge grows when you subscribe. Subscribe to learn something new every day.